Okay, let's call the meeting. Let me read this instruction here in the beginning of the meeting. This is a regularly scheduled meeting of the Board of Architecture and Engineering Examiner is taking place in Conference Room 1A of the Davy Crockett Tower, 500 James Robinson Parkway, Nashville, Tennessee. And notice that this board meeting was posted on the board website on April 1, 2013. With that, let's have a roll call.
Susan Ballard. Hal Balthrop.
Here.
Wilson Borden.
Here.
Robert Campbell.
Here.
Jerry Headley. Philip Lamb.
Here.
Bill Lockwood.
Here.
Rick Thompson.
Here.
Frank Wagster. Excuse me. Ricky Bersai.
Here.
Alton Heathcote.
Duly educated and accountable.
Stephen King. You have a quorum.
Thank you, ma'am. We have acknowledgement of guests. We have Candice Tolles from TSP. Welcome, Candice. Anybody else I missed? No? Okay. Announcement. Any announcement from the board here? Y'all know that David Suleiman cannot make it, so we're not presenting the certificate to him today. So, hearing none, review the agenda. Any changes, addition to the agenda? John, do we need to make a motion to accept the agenda?
And if you choose to, it's not required.
All right, with that, nothing, hearing none, then let's go on the consent agenda. You have before you the minutes of the February 2013 meeting. Attached, you see attached. You're going to be your iPad, you're going to look for it. So.
On page 3.
I would move to accept the minutes as stated.
I hear a motion to accept the minutes as stated for February the 2013 meeting. Do I hear a second?
Second.
All right, I hear a second. Do I have any discussion? Okay, hearing now, all in favor say aye.
Aye.
Any opposed? Okay, motion carry. Thank you. Staff complaint, John.
That's on page 9 on your iPads. You have a list of complaints for board decision in which the respondent was disciplined in another jurisdiction. The disciplinary action was less than a suspension or revocation, so in accordance with board policy, we issued a letter of caution and recommend closure.
Yeah, motion to accept the recommendation to close.
So moved.
Second.
All right, got a motion and a second. Do any discussion? Hearing none, everybody in favor say aye.
Aye.
Any likewise opposed? No, hearing none. Okay, motion carry. Thank you, John. Again, next go to, we can move on to the professional society. As you all know that the NCIDQ Mary Jane Grisby cannot make it today, so you all probably seen the revised agenda before today's meeting. So with that, I'd like to invite Ms. Candice Tolles from TSP to give us a brief report or update.
Listen up to the microphone. Yes. Okay. Wilson said I sent him a report, which means that I probably sent everybody else one too, but I'll go do the rundown on the major bills that we were working on this year. And I guess the biggest one of concern to you is the one that would affect Memphis, Shelby County, and codes, including specifically the seismic code, and allowing a local government to adopt a code that is less stringent than the state adopted code. And that is on hold for this session. It could very well come up again next year if we don't resolve something between now and the next legislative session. Fire marshal will get together the groups of people, interested parties, to see what they can work out. So that one's on hold. There was a bill to provide a STEM stipend, and the original fiscal note, and that's for anybody who's a student at a university who studying in math, science, engineering, technical. The original fiscal note was $7.4 million, and it's now been amended down to $250,000, and it would require a match in private funds. That bill is, I believe it's up in committee today, so I don't know what's happening to it, but it might pass in that form, as long as it doesn't have the fiscal note of $7.4 million. The bill to reduce the privilege tax to zero over 10 years isn't going anywhere, because it's got a $77 million fiscal note. We can dream, but the electrical safety code is now, the revised 2011 electrical safety code has been signed by the governor, and it's public chapter 56. A bill that would have required state agencies.
Just out of curiosity, you may have answered this once before, and if you did, I apologize, but I know engineers are subject to the privilege tax. What other professions, maybe I should ask, what professions are exempt from that?
Well, I know that the surveyors are exempt.
Yeah.
Was that the real thrust of your question?
Yes.
Okay.
And do we know why?
They hit a good lobbyist in 1992 when the privilege tax was passed.
Okay. Is there any benefit to petitioning the legislature to consider modifying the assessment of the privilege tax to incorporate other professions and potentially reduce the tax on?
I don't think the privilege tax is going to be reduced. There aren't enough surveyors to make up much money anyway, Alton.
But I mean, there are other, well, for example, just other professions under commerce and insurance. Are all of them assessed privilege taxes?
Interior designers are not.
Oh.
Well, we don't have a license, so.
They don't have a practice act.
Okay. What about hairdressers or morticians or
I don't think hairdressers are covered by the privilege tax either.
physical therapists? That's good.
I don't know about morticians.
Okay. Thank you.
Laundry list of them in the code.
Other questions on the privilege tax that I can stumble through? Okay, and a bill that I have been working on to kill would affect requiring state agencies to justify going out to the private sector for services. And it failed in House State Government Subcommittee after it had been amended to delete architects and engineers. Lawyers call that a belt and suspenders. And then there's a bill requiring manufacturers of products that are added to public water systems that would require what was originally intended to require all public water systems to test products and be assured by the manufacturer of the products that they were safe. What we found out was that the sponsor really wanted to get at fluoride. She didn't care about testing at drinking water level and that's going to go to summer study. So that's the breakdown on the big ones in terms, and then there are a lot of other bills that I'm watching, like the regulatory board's bill was up on the House floor today, and I don't know what happened to it because I was in another meeting somewhere else.
The one about civil penalties, or?
House Bill 142, it was the Commerce and Insurance Bill.
Certification Board, was that one you were talking about?
Oh, that was our bill, okay.
Yeah.
I didn't-
Did
yeah.
I not say that was?
I was looking at the Senate bill numbers, I was like, huh?
Oh, okay.
Yeah, House Bill 142, yeah, that one's,
That's
seems
the
to be
FE
working
exam.
through.
Yeah,
Right.
it's going just
It's taken
fine.
the 8-hour language out of our statute regarding the engineering exams.
And the things to report, architects and engineers Connie is really sick. She's having allergy issues, so asked me to make a report, but I'm going to include her in the report because we pretty much work together. The architects and engineers are meeting with the state architect right now and with contractors to on a QIC endeavor about different delivery methods. And Ricky was supposed to have been there too, but he was here because he had a duty to be here. There are lots of things going on with the state architect with regard to fee increases. Mostly the General Assembly has been consuming our energy. We'll have an annual meeting September 12th and 13th in Murfreesboro, and hopefully we'll have fun and interesting for for engineers. And I think that the City Center, I don't remember the date, but they're going to have a meeting at
one comment that this year at the convention, celebrating Connie's career and her retirement, so it should be a lot of fun. So
Are we having a roast?
I'm not sure. I don't know what all the circumstances are, but Connie said it will be interesting. Okay, so you need to come.
Could you get me on the agenda for the roast?
Yes,
Rick?
absolutely.
Okay. Thank you.
Thank you, Candice. Mr. Attorney, Robert, this is a legal case for you.
In.
All right. Page. And this is number 2012-01. The complaint alleges the respondent, a registered architect, committed misconduct by stamping phases of a project for which he was not qualified by education and or experience in violation of our rule. And the complaint materials were forwarded to Architect Board Member Mr. Thompson and Engineer Board Member Mr. King to review to determine if any probable cause existed for discipline. This respondent had a previous complaint last year that also involved plan stamping and resulted in formal discipline. So I'm just going to let Rick and Mr. King decide who wants to say what about it, because we had an informal teleconference with this person in which they both participated to find out who knew what and when. So if one of y'all would like to give the specifics.
Steve is going to present the specifics. I had requested that an engineer also review this to give a broader perspective on what this complaint.
There are two projects that were submitted, I guess, to the board office that forwarded on to us to review, and both of them are a very similar situation. An architect designed and stamped several different areas of a building. He did all the drawings himself, which included the architectural, structural, geotechnical, electrical, plumbing, and HVAC. I think the board, got this from I guess a plans review office. Was forwarded to us, and we did have a informal conference with this licensee. We asked, Rick and I both asked him a lot of questions. He did not have a site plan on either drawing, which was, in today's water quality world, was somewhat unusual, at least in my opinion. But I guess the biggest thing, this individual is a licensed architect, but he also has a master's in engineering. He's not a licensed engineer. We felt like, and Rick, you correct me if I misstate, but we felt like we could give him some latitude, in there's always some discussion about what's engineering and what's architecture as far as the structure. But when it came to the HVAC and the electrical and the plumbing, we could not find any level of expertise in either his education or his experience. So that was sort of how the informal conference ended, if I recall correctly.
Yeah, I don't think I think he failed to impress both board members that he was qualified.
In addition to this, this professional has 2 previous complaints. Did we mention that?
One was recent.
One was recent, and we dismissed it because it was a small addition to a building, and it was like an office, 12 by 12, or I don't remember the exact size, but he provided he provided structural on that, and it was residential quality, so there wasn't really any issue with that, and it had a through-wall motel air conditioner. I mean, it was just kind of a no-brainer, and so he hung his hat on the fact that we had fined him significantly, $4,000 on the first complaint. We dismissed the second, so he thought, well, this is okay. I can do this again. And projects. One was a assembly project, small, but still an assembly project, of which he did all of the drawings and sealed all the drawings, and they were incomplete. As an architect, if I had a set of drawings submitted to me by an engineer to that quality of development, I would consider them something I was supposed to review and mark up and get back with him, make sure he put in the unit sizes and the fan sizes and size the piping, the water piping, and what size hot water heater, and how were we handling the sewer, and I mean, none of that was there. It was very residential in quality, and as far as we're concerned, and we've talked about this, is that's out of his area of expertise, the MEP portion of it. And to make matters worse, to show what a great expert he was, he submitted another 20 projects that he's done that on. I mean, that's kind of a lot more rope there that you're dealing out. So that really convinced me that he thinks just because he has a master's in engineering, and I think you engineers have talked enough about that in these meetings, where that doesn't cut it. He had a practiced, and he kept saying, I'm qualified because I have a master's degree. We kept saying that doesn't mean you're a licensed engineer.
That master's is in structures, not mechanical or electrical.
Well, he admitted that he put in a fan that somebody else told him to put in. So
that was in the there's a warehouse that they store chemicals in, and there's a rather large exhaust fan. And when we asked him about that, it was just a recommendation from a supplier, I think, is how he sized that.
There wasn't any consideration, I guess, in how the air changes worked or how it evacuated the air in there if something needed to be pulled out.
I asked him for calculations, about how he did his calculations, and he said, well, that's what they told me to put in. So
you say he has done this 20 other
I don't know. I've
buildings
got the
or
file in here. I can tell you
approximately 20 other buildings.
I mean, there was a lot of.
He sent an email right before the informal conference that listed about 20 different projects that he had.
Be in a jurisdiction that has plans review and a code department?
I'm not sure. Can we tell where?
Well, I mean, the structures
it's
had
not
to be
in a
approved
rural
by
area.
somebody because that's how we found out about this project. Is it required a seal for approval, and the authority having jurisdiction said something doesn't look right.
Well,
That's how we got a hold of this complaint.
On this, what he submitted are 16 religious projects, which are all assembly type projects, and then 13 commercial projects.
Really, only defense was that he was a small company, and all the big companies got all the good work.
But he apparently got approval of the codes department and the plans review department apparently approved all of
At
these?
local jurisdictions, and, you know, it's the area of sophistication, as we all know, from way out in wherever in rural.
I don't know that he got a permit. Do we know whether he actually got a permit?
We don't know for a fact he got
Yeah.
permits in every case, but when I was at the fire marshal's office, there were times when a deputy fire marshal would drive by and the church was about halfway complete, and nobody had ever seen plans for it, and they pulled in, "Where's your plans?" We don't have any. So it happens. Things do get built without anybody even knowing about it until later. But the relevant facts here on these two projects is his competency level is suspect, but the thing that really aggravates me is that he was recently disciplined for pretty much the same thing for $4,000, which is not a small civil penalty. But that doesn't seem to have had much effect on him. So
And again, in his
he hadn't learned his lesson.
his own defense, the fact that we dismissed the following complaint, he said, "Well, it's obvious that you know, I can do this because you dismissed this complaint." But I tried to explain to him it was such a small project that, you know, he could do the structures on it. It's like we dismissed one recently that the architect did the turn down slab and foundation system. I mean, it's a small project. We're qualified to do that, but we're not qualified to do commercial electrical drawings. Your service to come and things like that, and that's what we do to give to the engineers, to give them an idea of what we're thinking. We don't execute that.
So I don't know what the reviewers are going to recommend to you, but I do think it merits some discussion because the civil.
That's where we sort of stopped in our conversation. I think I went on vacation, and then I talked to John. He said we would talk about it here, but I think we're left with a suspension or a much more serious penalty. I think that's what we left it to talk with the board about.
We did fine him $4,000 previously. And I think we have two options here. And I don't recall the number of sheets, but I do know it's two projects.
Well, they're about the same offense.
Yeah.
That's kind of what makes it worse. If it was like a completely separate issue, that might be something else. But we discipline just like we do kids, to teach them don't do it again, and he did it again. Discipline. So I don't know what the board would want to do in this case.
Are these two projects, they're both assembly?
One is assembly and one is a fertilizer manufacturing or storage facility. And, I mean, chemicals. Yeah, exactly. So his response on that was that the office space was less than 5,000 square feet in a 15,000 square foot facility. That doesn't fly, especially when the codes official required him to seal the drawings. And in the assembly project, that was it was even worse in that they decided, they being the owners and the contractor, decided to add a basement. Well, where's your means of egress in a basement? And I said, well, did they do it? He said, I don't know. He said, I just did the drawings. So
he's practicing outside his area of competence.
In the engineering portion, yes, and he's questionable in the architecture. But
if I were to make a recommendation based on what you've said, and I'm not saying that, but it sounds like we're looking at a minimum of a year suspension of his license and a high-figure type fine, like the $10,000 variety. about 2 projects, but he said he sent you over 20 that he has done.
Yeah, but have been no complaints on those. I mean, that's just
I think this, like we talked about, doing some turn downs on a foundation or extending a ductwork through a wall or something. Yeah, this is somewhere you're storing fertilizer in. That could get to be pretty serious pretty quick if you don't get that sort of.
Well, what kind of gets me is that the owner and contractor were going to add a basement. All he was saying is that he's doing the plans, and he doesn't know he doesn't even know that if they did it. You know, if it's me, I'm going to want to know what's going on, because it completely. And it's like the owner and contractor can do one thing. I've done the plans based off what we agreed to originally, and then, hey, whatever happens, happens. It's just, to me, it's scary.
Did we ever decide, Rick, is he in a jurisdiction that has plans review and a code and has to get a building permit?
He's in a jurisdiction where the building official turned him in.
It'll be either an
They
exempt
approved
jurisdiction.
him 20 times before that?
Not in this. This is his 3rd complaint, and that's why we were curious about, was there something going on between, personalities, and because we'd find him for one and dismiss the other, and it's the same jurisdiction that has turned him in again, because he stamped all the drawings. They send the standard form out. Qualified to do this, and then when they do that, they send it to us.
So there was probably the other times he was in a jurisdiction that either didn't have a plans review code official, or
It could
those
be.
people didn't understand what.
There's something like 33 exempt jurisdictions in the state that can review their own plans. If it's anywhere else, the state fire marshal will review it. So he's probably in an exempt jurisdiction, and it's likely that these other projects are simple enough, maybe, that they didn't see a particular problem, like he added a potty or a small kitchen or something, and did the stove hood and the wash sink and simple stuff. It could have been.
One thing I'll mention is that when we talk about simple, and then we talk about assembly like a church, they're not the same.
Oh.
There's nothing simple anymore about assembly as far as mechanical, electrical. You've got fire alarm issues, you've got ventilation code, you've got energy code the state now has. And if he didn't even have plumbing lines sized, I doubt he had the outside air in there that's now required, or did the calculations
Project's rural
to
enough
meet
that
the energy code now.
the project's rural enough that it probably was a septic system.
Yeah,
But he didn't design it.
And let me correct the statement I made earlier. He does show an unfinished basement on these plans, and I asked him if they had finished it, and he wasn't sure. So, toilets and air handling units and that kind of thing. And he sized the ductwork, and it's just a diminishing single trunk line that tapers down, and so I don't know.
I need a little bit more time to review, or you just want the committee to give you some help
Well,
on the board?
where we started out today when we were talking was probably we thought at a minimum would be, since there were 2 projects and he was practicing in 3 areas out of his expertise on both of those, would be a minimum of $1,000 each. So that would be $6,000, where he was 4 before, and then we'd talked about a possible 6-month suspension. So I mean, we're somewhere in between that and what Robert's saying. So
Why don't you all make it a formal recommendation, and we'll see if we got a second, then we can discuss it.
I can't do that. Right.
The recommendation on this particular complaint would be a fine of $1,000 per discipline on each project, and that's a total of $6,000, and a 6-month suspension.
The guidance forms that we have for that give you establish the penalty range from $500 to $1,000 per incident. So you're well within the guidance recommended.
Per incident, I'm reading to be per discipline. Then if that's per job, it would be different.
I would agree.
Yeah, so that's
I will second his motion.
Okay, I hear a motion that we fine per offender of $1,000 up to $6,000 per discipline, and suspension of the license for 6 months. And I got a second on that. The motion and second. Discussion. Open for discussion. Any discussion?
In the suspension of his license, I'm assuming that we'll include language requiring him only to practice in his area of competence.
How do you draft a letter? You suspend someone's license. I know when you come back, they have to reinstate it again, right?
Yeah, we haven't done many suspensions because they're so severe, because this really restricts their livelihood. If they're suspended, they can't do anything during that time. But if you want to put in the cover letter, the board instructs you not to practice outside of your area of competence ever, I'll come up with something like that, if you'd like. I mean, the consent order is going to recite the reasons why he's being disciplined, and that's practice outside of area of competence.
120-02-3, 1 and 2.
John, another question I have is that when you get ready to reinstate back, he has to reapply it, one more reapplication?
He can make it automatic.
The way suspensions work, they have to meet the normal renewal requirements, meet their continuing education requirements, etc. But it's automatic. I mean, after the 6-month suspension's up, we return him to his previous status. There's no reinstatement requirements for it.
Before we do that, is it okay to require him to take the law and ruin?
That goes without saying.
It goes without saying, okay.
He may have taken it before. I'm not. Probably has. So.
I guess
But it wouldn't hurt to take it again.
We've had other incidences of people that are practicing beyond their competency. Do we consistently suspend them?
No, but they're not repeat offenders either. This person's already been assessed a civil penalty.
Also, maybe they didn't admit to practicing on that number of previous projects either. They've had 20, did you say? At least 20 previous projects?
I think it was 36.
A lot. And then also his most recent case then, about a year or so ago.
And I asked him if he provided the same level of services on these projects, and he said yes, he did. But he did say that he was working closely with contractors, subcontractors, and the owners in developing what those packages would be. So, Wilson, you got a good point. Is that the only time I remember suspending a license was when we were in Memphis 3 years ago.
There's 2. Yeah.
Fine, thank you. But it was for multiple plan stamping incidences where someone prepared documents for assembly buildings, and this architect stamped those drawings, and the city reported him, or the county, whoever the inspection department was, and also the drafting company who prepared his documents that he stamped, and we gave him a substantial fine and a 6-month suspension. And for us for a formal hearing, which it's totally his right. So if anyone thinks that that's too much, I mean, now's the time to.
I think we talked to him when we were in Memphis.
Came before us for a formal hearing.
It was an informal.
Oh, informal. I'm sorry, you're right. And then we made the recommendation, and he accepted it.
So we've done it before in cases like this.
Mr. Chairman, I think this is a fair penalty due to the fact that it's a repeat offense on the same offense. And based on his conversation with Rick or Steve, he acted like what he had done, but he hadn't gotten it from the time he did it before. And you would think that if you've done this and gotten that pretty substantial fine, that before you kind of went down that path again, you would at least kind of check multiple times, or maybe even call the board or something and say, am I getting ready to get in the same kind of mess? And it doesn't look like he took that same kind of caution, and I don't know that we want people like that out here practicing. At least more substantial deterrent to doing that, for a little.
Council? Thank you. Any other discussion? If not, let's call for a vote with a motion and a second. Discussion is closed. Those in favor of the motion?
Aye.
Any opposed? Motion carries. Thank you.
6 months suspension.
6 months suspension and $6,000, which is $1,000 per discipline.
Law and rule exam.
Law and rule, that's right.
And by the way, on the $4,000 fine, he did take and pass the laws and rule exam.
Version B of the law.
Just passed it.
Just thought I'd throw that up.
They didn't say he retained it. He said
Crammed for the.
All right, Mr. Attorney, next.
Number 2. This is 2013-001201. The complaint alleges the respondent, an unlicensed person, was offering engineering services without a license. Specifically, the activities involve conducting a roof evaluation and making engineering conclusions as to the condition of the structure and engineering recommendations as to necessary remedial measures. This one was reviewed by Mr. King to see if there's anything that merited discipline. This person doesn't have a complaint history, so Mr. King again.
I think this person did have a license.
Oh, was it an engineering license?
This is the one where about the hail damage assessment. Yeah, he did have a license. Well, I think what I was supposed to do was to review it to see if he was practicing outside of his area of expertise. That's not the right one.
I think he's licensed in another jurisdiction, but not in Tennessee.
There's lots of Mr. King ones on here. I think that's the next one.
That's the next one?
This person was not licensed. He was a...
Well, I don't remember that one then. You're going to have to refresh my memory.
Licensed, not licensed, as in not licensed in the state of Tennessee, or was he licensed somewhere else? In number 2.
I can't remember for certain.
Now all of our complaints are electronic, so I don't have the file with me. But it sounded like... Do you remember what he... Mr. King? I think you told us that, yes, this person was making engineering conclusions, because I made notes about... You felt that that was indeed the practice of engineering, and this person was not an engineer. He went a little too far. He said he made conclusions about the condition, the damage that was taken. Then he made engineering recommendations on how to remediate the damage, which you felt was the practice of engineering.
Stephen, is it you feel comfortable with just maybe put this off this case since you don't remember?
We'll get the...
Either that or maybe at a break I can see the file.
I'll call
don't remember
Francis
that
and
one.
get her to bring the complaint file
thank you.
over.
It wouldn't be fair to the
Present it
respondent,
later.
obviously.
Can we just put item number 2, case number 2, and if you want to move on to case number 3?
3 is another Mr. King. Let's see about this one. This one's 2013-002171, and this one is alleges the respondent, an engineer, committed misconduct by stamping phases of a project for which he was not qualified. And these complaint materials were given to Mr. King, too. I think we can bring that one over.
Refresh my memory on that one too.
provide you with that shortly. So let's move on to number 4. This one's one of Ricky's. Complaint 2013-002681. And this complaint alleges a respondent, a registered engineer, committed misconduct by engaging in activities that could constitute a conflict of interest in violation of our rule. And Mr. Bursai reviewed this to see if there was any grounds for discipline.
Okay, this complaint was made by a contractor who hired a PE, and the PEs bid on jobs to other contractors to win some work. And the complaint really, there were 3 points to the complaint. One, that the PE didn't win any bids for the company. It was kind of a new startup company. That the PE attempted to work some side deals with the general contractors that he was bidding to, and then that the PE was guilty of sexual harassment. There is the PE had worked for this contractor for 11 weeks, and the respondent countered and said the allegations are untrue. Noted that there wasn't any street address on the complaint for the contractor. He had asked for the contractor's certificate when he would go bid jobs, so he could provide that, and there was no. I think his boss was annoyed that he said his boss was annoyed that he asked. I think the PE claims that the contractor, his boss, filed this complaint to discourage the PE from trying to get the salary he was owed. So there was some kind of dispute there about payment. The PE promised the complaint. The contractor said that he was hired conditionally to win jobs, and that was tied to his payment. He has contacted an attorney about this complaint and about his So in reviewing the complaint, the items 1 and 3 aren't subject to our laws and rules that we are reviewing. I couldn't find anything about sexual harassment in our rules, and the fact that he didn't do his job good enough isn't anything that's against our rules. Didn't win any jobs. Leaves us with this attempt to work side deals, which would be potentially the conflict of interest. It could also be there's a passage in acceptance of work and a passage in misconduct about this kind. Really no proof offered. It's just a statement by the complaint that says I tried to work side deals, and
To that, did he list any beneficiaries to this side deal?
Not for that.
Okay.
There was the only proof that when I looked through, the fact that he didn't win any bids is kind of proof that he either didn't offer side deals or it just wasn't good enough. So
there's no substantiating.
The only data he had in there were about the sexual harassment claim. There was nothing supporting this claim of
really outside our purview.
So talking with Rob, there's really not enough proof here for us to do anything, and we talked about keep the case open in case some proof is provided, or if they go to court and prove this issue, but it doesn't seem like there's enough proof for us to do anything.
What we would do is close it for lack of grounds, and then if, like Ricky says, they go to court and the record shows that one of our licensees did something that qualifies for discipline, we can reopen the case. But as we're sitting here now, there's just not enough.
Your recommendation, Ricky? Can somebody make a motion for him?
Recommend that we close this case for lack of proof and information.
Yeah, second on the motion.
I second.
All right, thank you. Any discussion? Hearing none, those in favor say aye.
Aye.
Motion carried. Thank you. Thank you, Rick.
Right, number 5 is 2013-005781. This is one of Mr. Wagster's. This complaint alleges the respondent, a registered engineer, committed misconduct by stamping phases of a project for which he was not qualified. And this material was sent.
And I've got to claim green and being green just a little bit, being not prepared for this. There were 2 or 3 of these that came to me and I reviewed, and this is one of them, but there's not enough information here for me to remember which one it was. I also had a written response that you should have.
We've started, we don't have paper files anymore. That's one thing we started doing. Everything is stored on the computer now, and I don't have any. This is a drawback, obviously, because I don't have the files with me because they're on our hard drive. We're gonna get Francis to bring that file,
Yes.
just like for Mr. King, and refresh you. I would if I had the file with me, but I don't have it.
If I
Maybe
had
she
some
just needs to
clue
bring the
which one it
whole
was.
file system, the whole file cabinet.
Yeah, let's bring everything over. All right, we'll punt that one. The next one is Miss Ballard's, and I know she knows about this one. So,
I'm ready, guys.
all right. Number 6, 2013-004641. And this complaint alleges a respondent, who's a registered interior designer, committed misconduct by publishing the interior designs created by the complainant, who's another interior designer, on the respondent's website without crediting the complainant, in violation of their rule on professional conduct. And then, like I say, the complaint materials were forwarded to Ms. Ballard to review for probable cause for discipline. We had an informal conference on this one, too, with everybody involved. She did a great. What's the timeline here?
All right. In late 2010, the complainant entered into a verbal agreement to work through the respondent's design firm on a residential project that would be included in a charity event known as the Homes of Distinction. They also agreed upon amount of sales of furniture, art, and accessories in the amount of $30,000. The respondent also agreed to assist in the design process to include setting and staging of the home for the charity event. Sales on the project exceeded the verbal agreement. No written contracts existed through this process, as stated by both parties, since they had worked together for 16 years. The complainant performed the services required on the project with the assistance of the respondent. Photos were made of the home so that items used in the staging of the show would be identified and later removed. In May 2012, the homeowner was told by personal friends that their home was on a website known as house.com. The photos have been posted by the respondent without the verbal or written consent of the homeowner or complainant. The photos did not mention the collaborative work between the complainant and the respondent. Upon reviewing the website, the homeowner called the complainant and requested that the photos be removed. The complainant had a meeting with the respondent requesting that the photos be removed immediately, and the respondent agreed to do so. According to the respondent, they had a verbal agreement from the husband to post the photos on their Facebook page. The respondent's daughter has sent a letter testifying to that conversation. To date, the respondent has not supplied written consent to post photos of the design project on the house.com website from the homeowner. The respondent believes that she has the right to post the photos of the work they performed on the project. They provided photos that were labeled with the work that the respondent had performed. They also stated that they did not know that they had done anything wrong. In our informal conference calls, all parties involved, it was revealed that the homeowner was very upset that their home was posted on the house website without permission. They were also upset that the respondent had not given credit to the complainant's work on the project and felt that it was very unprofessional on behalf of the respondents' actions. The respondents' photos were cross-referenced against the photos of the complainant's Facebook page, and I found 8 photos that were the same on both websites. The day before our informal conference calls, I rechecked the websites and found that the respondent had removed all of the photos from the Houzz.com account and their Facebook page. In our interviews, the respondent claimed that she removed the photos in 2012. And at this time, we'd like to open it up to board for comments.
So basically, this situation isn't about performance as an interior designer as much as it is about ethics, where somebody was utilizing somebody else's work for profit. So it makes it a little bit different. So I think Susan's interested in hearing how you feel about misuse of somebody else's work product.
And lack of permission for having the photos
I
on.
can speak to that personally. I had a partner who, not recently, but fairly recently, left the firm for various reasons, and he set up his own website. Excuse me. He was been at the firm for 12 years, and he used all of our photographs. And we immediately had an attorney contact him, and they were off the next day. So I didn't file a complaint because he complied with what the attorney told him to do. So it's very frustrating when you have these award-winning projects on someone else's website, and just because they worked on them when they were with you or for you doesn't give them the right. I'm very sympathetic to that.
That's right on point. That's exactly what happened.
Susan, did you say the husband gave approval for her to put this?
On Facebook, there was a second website that was used that no one was given permission to post photos on, and she did not give the original designer credit for any of the work on Facebook or Houzz, which if they did it together, both names should have been on there. But they didn't have permission to post the photos, and she didn't give credit for the work. So to me, there's 2 misconducts involved in this particular complaint.
I want to explain what the Houzz website is,
Okay.
what it's for, and the difference between social media and a website where people go to see if they want to buy something.
Well,
I think is
and I had never heard of it because I don't do residential work, but the Houzz.com website is a place where designers can post their work, and the respondent had her name, her company name, and post pictures of all types of things, but they had pictures of that particular project on there. It did not show at the time that I saw it the name of the project, but other people knew it was the homeowner's project, and that's how it all got started. The Facebook page had the same pictures, and then the complainant's pictures, when I cross-referenced, there were 8 pictures that were the same on the 2 websites. So there were other pictures that we were given, but those were the only ones that matched up. So
But they had permission to do Facebook.
they have written permission.
And did they cross-reference those to give credit to the other?
No credit was given.
So that's kind of a vague what that permission.
Excuse
allowed
me,
them.
let me back up. The complainant has written permission to post photos on social media. The respondent has 0 written permission. They had 1 verbal permission for Facebook. So the Houzz.com website, there was no permission given by the homeowner. And that's where she was, informed and was very upset about. So
There are 2 sections under the rules for interior designers under professional conduct, Rule 0120-04-.1, Section 4. The registrant shall not engage in any form of false or misleading advertising or promotional activities.
and then number 5 also.
And then number 5, which the registrant shall not divulge any confidential information about the client or the client's project, or utilize photographs or specifications of the project without the express permission of the client. So there's 2 distinct violations.
Just a quick thing, and I don't have any recommendation, but just something else to kind of consider. They were collaborative on this project, so I mean, it wasn't like she didn't have anything to do with what was on there. I mean, that's, which I think is a little different than Rick's case because that person was under your purview. I mean, that was your deal on that. And the second thing, I mean, on some level, and again, this is just something to think about. Once it gets on the internet, I mean, whether it's on Facebook or my book or whoever's book, it's on the internet on some level. So, you know, it's kind of hard to start splitting the baby at some point when you get down there. What do you get permission to? Because once it gets on the internet, it could go anywhere.
When we interviewed the homeowner, she felt like there was a distinction because one was more of a private social media and one was an advertising media.
That's like a big portfolio
Yeah.
of your
So-
work. That's how you sell your work.
Yeah, she did not want her home on thehouse.com. And she's a very educated individual and very outspoken. So,
Of the design itself, was it done under a firm?
both. The complainant was a former employee and now an independent designer, but had worked collaboratively with the design firm for 16 years. So they had no verbal agreement, well, no written agreement. You know, they never had a problem in the past. But this particular situation, I think with the economy being, you know, stressed as it was, people may do things they probably wouldn't have done otherwise. But
Firm name was on the designs themselves at some point, I would say.
well, there's two firms involved. There's the complainant and the respondent. The respondent is claiming credit for the complainant's work. The complainant had a contract with the general contractor to do the design work. The respondent was asked to help. And she put her name on the photographs on two websites without permission. Well,
Plaintiff owned, and based on what you just described, the intellectual property.
my recommendation is a civil penalty, a letter of warning, and a requirement to take and pass the laws and rules. So,
Letter of warning or letter of reprimand?
warning.
If you assess a civil penalty, that'll be the cover sheet for the settlement offer, the consent order.
Have a motion?
You want me to tell you a dollar amount? Okay, I'm recommending $500. You know, she did say she was sorry. She didn't realize she had done something wrong. So they
Let's
have been
restate.
removed.
So let's restate your
Okay.
recommendation.
I recommend that we have a civil penalty of $500 for misconduct of Section 012-04.10.4 and .5 under professional conduct. Send a letter of warning and a requirement to take and pass the laws and rules exam.
Second.
Good. Any discussion? Hearing none, all in favor? Aye.
Aye.
Any opposed? Motion carried. Thank you, Susan. Next one is on the privilege tax case. Huh?
Yes. 500 civil penalty law and rules. Okay. There's actually one on, I think, on your pad, but there's actually four of them. But they're all the same, so it's easy peasy. Number one is 2013-002081, and I'll just go ahead and tell you all of them were presented at the February 13 meeting. And they all allege about the same thing. And the first one, this was a licensed engineer. He failed to keep privilege taxes up to date for at least 2 years, despite being notified by the board staff. At the time, the recommendation, which was approved by the board, was to authorize a formal hearing and a consent order to suspend registration until all delinquent taxes are proven to be current. Since the last meeting, the respondent has provided the proof. So the recommendation is to rescind the consent order and issue a letter of warning to maintain all licensure requirements.
Recommendation to rescind the consent order and issue a letter of warning to maintain all licensure requirement from our attorney.
So move.
Second, any discussion? Hearing none, all in favor say aye.
Aye.
Aye. Any opposed? All right, motion carries, sir. Thank you.
Number two is 2013-002001. Same thing. This person was an architect, and he was at least 3 years delinquent, despite notification. in violation of the rule that we have for misconduct for this privilege tax. And since that time, this respondent has provided proof that all obligations are current, so I recommend rescind the consent order and issue a letter of warning to maintain all licensure requirements.
Quick question, did they acknowledge receipt of the notifications?
I would think not. Like, once again, I don't have the dead tree version, but if they ignored, we send them regular mail, a notice, the board offices.
It's in one certified mail, too.
Then the second time it's certified.
Right.
So they get notified twice. We don't hear anything from them, so it comes to me. And then you vote to send them a consent order to suspend them until they prove that they're current. Well, these individuals have gone to Revenue, and Revenue has told us that they're current. That's what we require. They can't just call up and say, I'm paid up. We have to get proof from Revenue. And these people have done it. And when they do that, then I bring it back like I'm doing now and have you rescind the consent order, send them a letter of warning instead. There's like 20 of them last time. There's only 4 of them that have repented, so the rest of them went to formal hearings.
You get something by certified mail, there has to be an acknowledgement of receipt, right? Okay.
Got proof of service.
Okay.
We wouldn't be able to litigate it without that.
I would move to accept the attorney's recommendation.
Motion, do I hear a second?
Second.
Okay, any discussion? Okay, hearing none, all in favor say aye.
Aye.
Any opposed? Motion carried. Next. Thank you.
Flush, rinse, repeat. Number 3 is 2013-002021. This one was presented at the last meeting. This person was an architect, at least 2 years delinquent on privilege tax in violation of our rules. And since that time, this respondent has provided proof that all obligations are current. Recommendation is the same: rescind the consent order and issue a letter of warning to maintain all licensure requirements.
So move.
Second.
Motion with a second. Any discussion? If not, all in favor say aye.
Aye.
Any opposed? No. Motion carried. Next, sir.
Last one of these. So 2013-002161. This was presented at the last meeting. Person was a PE, and they're at least 2 years delinquent in violation of our rule. So at the time, I recommended a consent order to suspend, which y'all approved. Since that time, they've provided proof that all obligations are up to date, so I recommend rescinding that consent order and issue a letter of warning to maintain all licensure requirements.
So move.
Got a motion, a second? Any
Second.
Okay, second. All right. Any discussion? Not, all in favor say aye.
Aye.
All in,
It looks like
motion carried.
looks like the complaints have arrived, so I would like to ask the chair if maybe we could have a break, let the reviewing board members
Director's report.
take a look.
Okay. We could do the director's report if you want.
Oh, I think
Give a little
Bobby,
chance
good,
to
just
get up to
because
speed.
right after lunch, can we maybe just take 5 minutes break? Is it 5 minutes enough? Okay, 5 minutes. Okay, be back here about 10 after 2. Thank you. What? 5 minutes break. Oh, 10, okay. Did someone make a motion? 10.
No motion. I can't believe it.
Drive me home.
Ready? Okay, director's report.
What page number?
Well, the statistics start on page 15, but I have some other comments before we get to that. National Council meetings. Bill Lockwood attended the CLARB Spring meeting in Scottsdale, Arizona on March 1st and 2nd, and he'll give us a report on that meeting later on the agenda. Rick Thompson, Jerry Headley, and I attended the NCARB regional meeting in Charleston, South Carolina on March 7th through the 9th, and Hal Balthrop Ricky Bursai, Rob Herndon, and I attended the, sorry, I purposely
Rob.
mispronounced his name, attended the NCAAS Southern Zone meeting in Biloxi on April 4th through the 6th last week. And we will report on those meetings. Other meetings, Bill Lockwood and I represented CLARB at a career day that was sponsored by the UT Knoxville College of Architecture and Design on February 22nd. And that was very well attended. We had quite a few students that stopped by, mostly landscape architecture for our table, but NCARB had a table set up right next to us, so we also talked to some architecture students, and a few interior design students stopped by as well. So I think that was very useful. Robert Campbell attended a professional development event on engineering ethics and PE licensure that was sponsored by the East Tennessee section of ASME on March 20th. How did that go, Robert?
Good. It was I was one of a 3-person panel. We got to review some sort of ethics tape, which is a little goofy, to be honest, and then talk about it, just different things going on in engineering ethics. So, I mean, it went all right.
Okay, good.
Did you get in a fist fight?
Oh, like I said, the ethics tape was so egregious that it was hard to, do some of those real fine line things.
Oh,
But it
not
was-
like the Gilbane Gold scenario. I mean.
somebody and hindering his daughters or something. I don't know. So
Great.
it went very well, and that's a format that we ought to try to foster in some other applications too. I think it worked out pretty
Good.
well.
Thank you for doing that. Kept me from traveling to Knoxville, and yeah, that was useful. Hal spoke to engineering students at Tennessee Tech on March 27th, and I guess you'll do it again in the fall, right? Yeah. And I will be speaking at the Tennessee Building Officials Association Annual Conference in Gatlinburg on April 29th to provide updates on board activities. Carolyn Lazenby, who's Executive Director of the Contractors Board, will also be presenting to provide updates on their activities. And also representatives from the State Fire Marshal's Office will be speaking. Other issues, the rulemaking hearing rules that were approved at the August 2012 meeting were approved by the Joint Government Operations Committee on February 25th, and they took effect on March the 11th. Obviously, this building is undergoing renovations. We will be moving to the 5th floor of this building, the Crockett Tower, on Friday, May the 3rd is when that move is scheduled. So we'll be moving from the Johnson Tower down the street back to this building. This is where we were for many years. So
I like that better.
it will be a much smaller office space than what we have, and we have a much bigger space now than what we need because almost all of our files have been scanned at this point, so we don't need all the file space that we formerly needed. But it's still going to probably be a little smaller than what we would like to have, but we don't have a lot of say in that. So, yes, densification. They're packing more employees on each floor, so it'll be an adjustment for us. But it's certainly going to be, in many aspects, nicer than where we are currently located, and much nicer than our old space in this building, which was far worse than the old space where we are now. So it'll be an improvement in many ways. But we last moved in 2008, and I think when we move back to this building this year, we've probably got less than half of the stuff to move this time compared to what we had last time, because we've scanned so many of our files. Last time, most of the boxes that we transported were loaded with files, and we just don't have that anymore. So for the most part, we still have some files left that we haven't scanned, but the vast majority have been scanned. So I think that's a good thing. But we will still have some storage space. Also, there is a possibility that our toll-free number, 800-256-5758, that may be disconnected as part of a cost-saving initiative. That's something that's occurring statewide. The executive branch has a total, I just thought this was an interesting statistic, a total of 22,666 toll-free numbers at a cost of $1.5 million. I guess that's a year, I'm assuming. So I had no idea there were that many toll-free numbers. So they're disconnecting all non-essential numbers.
Do we know how many people use the toll-free number to call in?
Yes, we do. I have those statistics. We receive, just in the last 6 months, we receive an average of about 170 calls a month. The average cost is $8 a month, so it's very negligible, the financial impact on our board. So we've submitted that information in the hope that we'll be able to retain our numbers, since we do get a fair amount of calls on that number. I think actually they were surprised at how much use it received. I know the accountancy board, they have a toll-free number. Their number, they're lucky if they get 50 calls a month on their number. So
We got a good number. The number is easy to remember.
hopefully we'll be able to keep it. I just wanted to make you aware of the possibility that it may be disconnected. So we'll deal with it. Let's see. On page 15, you have licensing data for your review, showing the number of in-state, out-of-state, and total registrants. On page 17, you have the number of licensure applications reviewed and approved for the fiscal year. These are just reports for your information. And beginning on page 18 is the list of open complaints. And this is just a snapshot of all open complaints as of April the 2nd. And you'll notice that at that time we had 41 open complaints. 9 of those, or 22%, were over 180 days old, but all of those have had clock stopping action, which means that a formal hearing has been authorized or a consent order has been issued or something of that nature. We've got 9, at this time we had 9 hearings to be heard by the board, 15 by an ALJ. Those were privilege tax cases. I think that number is actually reduced now because we've closed some at this meeting. And the percent on time in the last 18 months is 98.11%, which is well above the department's goal. So still doing good on complaints. And behind that on page 20, this is just the fiscal year report showing complaints open, closed, civil penalties assessed, collected, etc., just statistical information. There's a strategic planning report behind that, which I think was started under the Bredesen administration. We're no longer required to provide these statistics, so I think we're probably going to delete this report in the near future, because it's one of the purposes of it was to show the percentage of registrants that for whom complaints are opened against. I'm not sure how to phrase that, but it's always like, 0.001% or something of our total registered population that ever has a complaint opened against them. It's a very small percentage. So that was a statistic that we used to keep. We're not required to report that anymore, so that report's probably outlived its usefulness. And finally, on page 22 is pending legislation report. Candy's already gone over a lot of these. You can see our bill that prepares us for the computerization of the engineering exams by taking the 8-hour written language out is progressing. I don't think there's any doubt that that will pass without problems. There's another bill, Senate Bill 149, House Bill 143, that is also tied to our division, Reg Board's division, that prohibits renewal of a license if they have unpaid civil penalties, and also allows for electronic submittal of complaints and applications. That has passed. I think it's still awaiting the governor's signature. Another bill, Senate Bill 493, House Bill 422, that requires expedited issuance of licenses for veterans, has passed as well, as anticipated. Still not certain of what all the implications of that will be, if that's going to require rule changes. Don't know at this point, so we'll see. I wouldn't expect it to have a big impact on us, though. Right, and it has been amended some. I don't think the amendments substantially change the legislation, but yeah, we'll have to see what the final version is and then assess what its impact will be. And that's really all I would draw your attention to. Unless you have questions, that concludes my report.
Notice you don't have a financial report. Is that you're going to do it every other month?
Right, we'll have the third quarter financial report at the June meeting because we don't have the final numbers for March yet. That'll come later in the month. So that's why we don't have the financial report this time.
I think we asked this question before in the past. When we assess a civil penalty, where does the money go to? General
It goes
fund?
in
We're
the
not
general
gonna keep
fund.
We're not going to keep it.
Not designated to us.
It goes right into the general fund.
John, we did. Thank you. Any other question for John? No, I'm going to go back to our attorney to finish his case.
I think we're on page 2 of the legal report. I don't remember what page it is.
Case number 2, right?
That's page 11, yeah.
All right. I've already read it into the record. This is the one that is an unlicensed individual, has no design professional degree at all, and was involved in evaluating a roof, and the complaint alleges providing engineering services or architecture services without a license because this person drew technical conclusions and made recommendations for remediation. So Mr. King, I think, has had a chance to take a look at it.
It's been a while, but now I remember.
Yeah.
This individual is a registered architect in another state and prepared a report for a commercial building in Tennessee and noted damages from the hail and recommended solutions. And I felt like when I corresponded back with Rob that this was a practice that would be regulated by this board. This person's report even mentions that he's an architect, that if you didn't know better, you would assume an architect in Tennessee. But he's not licensed in Tennessee. It's a question maybe for our architects. I think this report is a practice that would fall under the purview of this board. It seems to me that one might argue whether it's engineering or architecture. It's one of the other. It's dealing with damage to a building from a hailstorm. If a engineer had come in, I probably wouldn't have quibbled over this kind of report from an engineer or a person isn't licensed as either in Tennessee.
It would, statute 62-2102, section A, which says that a person cannot use the appellation architect, engineer, landscape architect, or an appellation which compounds, modifies, or qualifies the words architecture, engineering, or landscape architecture, which gives or is designed to give the impression that the person using same is an architect, engineer, architect. I think Mr. King mentioned that this person did say he was an architect. Not a Tennessee architect.
Is an architect.
Is an architect. Just
But our statute.
Not registered.
Did he seal the drawing?
No.
The report?
A quick question: what was the nature of? Did he make recommendations, and where it was it? Hey, you've got pits, on the gutters, consistent with hail damage, something like you would get from an insurance adjuster, or was it?
It's more detailed than that. He
Okay.
would repair damage to roof in sections A and B, remove and replace the metal roof, including the metal building inside.
And he was making recommendations on
The
material
ephes on the
replacements
triangular
and stuff.
parapet. I mean, it's
Pretty detailed. Okay.
well.
okay.
I mean, it's not.
But he's making recommendations on
Yeah.
materials and stuff
Yes.
that you would go to. Okay.
Yeah,
Okay.
it's not.
I understand. He didn't just say there was damage. I mean,
He didn't
a lot of
provide
times-
any drawings, but he had some verbal instructions on how to repair the building.
Who were these recommendations directed to?
Ed, who hired him, might have been an attorney that hired him.
Do we have who filed the complaint? Was it building official or owner or an architect?
I don't have that information.
No. I bet that's in the paper file.
Yeah.
I have the paper file.
I think the building is a commercial building. The complainant is not a party to any complaint. The only parties involved are us and the respondent. The complainant's just the vehicle, the way that we learn of the violation. So as far as coming to a disciplinary decision, we don't really need to know who filed it, although it's always clarifying to know that. But if it is a commercial building, it was probably the building owner, or if it's involved in a lawsuit and a lawyer asked for it for the purpose of litigation, that's a possibility, but that doesn't get them off the hook, I don't think.
Sounds like he's clearly violating our law and rules.
Giving
So
the impression that he's a licensed Tennessee architect by using that term.
He's misrepresented himself.
Didn't say I'm an architect in another state.
His recommendations were done on his letterhead?
Yes.
I'd like to hear a recommendation from the board, see what we should do, whether we should, what should we fine him, how we handle.
May I ask one question?
Sure.
If he was offering engineering services, based on what I've heard, I don't see that that's engineering services. Is there more information with that, Mr. King?
We don't define engineering and architecture in Tennessee. I think this is one of those things that if someone submitted this report as an engineer or architect in Tennessee, I don't think this board would quibble over which registrant did it. Now, I'm pretty new to this, but I think that's the way that we've operated for quite a while. Now, you know, engineers might argue it's engineering, and architects might argue it's architecture.
Well, he did provide a service. His recommendations for repairing a roof with some instructions, you know, it's clear that he had a contract with somebody. And I think had he identified in his letter that he was not licensed in Tennessee, he would have been covering himself. But if he didn't have that, then one could presume that he was licensed in Tennessee, and that would then be a violation of our rules.
Thing too, and I don't know if this is kind of a question for Rob too. If he was hired by an attorney to do an evaluation of this roof, then really it's not, I mean, he could have been an architect from Mars. It's really it would then be the judge's decision to decide if he were an expert and his credentials were correct. And if the correspondence was between he and the attorney, then that's, I mean, it's not protected, I know, but it's a different correspondence than if he were putting this out for public, to go fix the roof in a public way as a bid document or something like that. And that's the only thing I would be wary of. So you can call yourself an architect in court if the judge says you can. Correct?
It's possible, but unlikely. If I was an attorney, I wouldn't hire a non-registrant as an expert.
But people are hired as experts that are not registered in a jurisdiction.
They'd have
because
to
they
be-
happen to have a specific
Yeah.
type of expertise in another jurisdiction.
They'd have to be very specialized in whatever the
Right,
subject matter
understand.
was.
But I mean, that's possibility.
The first question out of the other attorney's mouth is, "Are you licensed?" And you don't want the answer to be no. It sort of erodes the veracity of the person.
We don't even know if this was a court case or anything, though, do we? So we're just kind of talking and speculating here.
Well, I would think if an attorney was involved, it was probably an insurance case. It probably
Oh, we
wasn't.
don't know, so
was an
I-
insurance
I agree
Yeah,
with
issue.
Will.
if it was hail damage, then
We can't presume anything if it
No.
affects someone.
The
us
insurance
taking
company-
action against someone. We need facts. And
somebody submitted a claim, the insurance company wanted verification of something. But what we're concerned with is two things. This person is using a term he shouldn't use because it's misleading. He's calling himself an architect, and he does not have a license here. And he didn't make that clear. The other is if the actual activity, in the opinion of our engineer or other design professional, qualifies as the practice that's regulated by this board. So there's two things. He's definitely in violation of one, using the term. He could be in violation of actually providing those services when he's not supposed to. And I don't think he distinguished.
But when you write a report on a structure in Tennessee, and you issue a report that has the
Findings and
name of
recommendations.
your firm with findings and recommendations, then you are practicing in Tennessee.
structural comments or structural aspects.
I would say it was very minor structural. They were minor structural recommendations. Well, that was what I read to Robert a second ago. That was one of his recommendations.
Mr. Balthrop, please be sure to speak into the microphone.
Thought is that I had a roof damage, and the insurance adjuster came out and made similar recommendations for decking and roof replacement, and they weren't licensed anything, I don't think. So I just think we need to be careful that
I don't think an adjuster would come out and say, yep, it's damaged, and then would probably report back to the insurance company that your building has sustained damage, and then the insurance company would then hire somebody.
No, the insurance company doesn't hire anybody
Right.
most of the time. They take their employee's opinion. At least that's what happened in my case, too, and I got a check. And this seems to me like this person offered a letter of opinion, that he was asked, take a look at this and tell me what you think I ought to do. And the guy looked at it and told him what he thought he ought to do. And I'm assuming the guy went and hired him, hopefully a Tennessee architect or engineer, to solve his problem.
Was the public at risk at any time as a result of this evaluation or action on recommendation? I don't see it, and that's what we're charged with, I think. Does it affect public health and safety, or including or involving the practice of something that would do such? And I don't think
If this guy, I would agree with you if the guy had said, yeah, I'll take a look at it, I'll give you a recommendation. Yeah, I've looked at it. It looks like you do have some real damage. You need to get a registered professional in this state to come in here and give you a report, so that you can enter whatever claim for damage is merited. He didn't do that. He actually came over and wrote a big report of findings and recommendations, practicing architecture without being duly registered. To me, if he wrote that report and gave recommendations and conclusions, he's practicing architecture in the state without a license, without being duly registered.
I have a question. The reference manual, doesn't it, or we don't have it on the, is it?
Yeah,
Oh,
it's,
okay.
What are you looking for?
Just the definition of what's allowable. For example, if UTC or somebody wants to replace a roof, if they're not doing structural repair and replacement, they don't necessarily need a registered professional. But if you have structural issues that affect the HSW, then it kicks in that you have to have a licensed professional to make those roof repair recommendations.
That deals with normal maintenance or repair of an existing roof. I'm not sure if it's all under normal maintenance
Not normal.
or
Normal
repair.
would be
Normal would be my roof's leaking and it's worn
Yeah,
out. It's
and you fix
25
it.
years old and I
Right.
need
This
to put a
is
new roof on.
storm damage.
hail damage is wrecked, and you got to repair it. not wear and tear.
Incidental to natural causes, but
Yes, yeah, but it's not wear and
just
tear.
just the structural question made me think about that because I don't know, would an engineer or and I know what you're saying, Wilson, about a roofing appraiser. I mean, they're licensed appraisers. That's what they do. They come in and say 100% of the roof's damaged and we're going to guesstimate 20% of the decking replaced. We're going to pay you $8,000 or whatever, and then you go get it fixed. But they're licensed is the point. And then my point about the structural replacing the decking is that kicks in the manual the need for a licensed professional. Am I correct or not?
Somebody's going to use this information to repair that roof.
I know, but I'm saying per the manual, and I hadn't pulled it up.
Yeah.
I'm just since you've got it.
It's normal maintenance or repair of an existing roof where the weight, drainage, fire protection, and other code-related requirements of the original design are not changed or compromised. In those situations, a seal is not required. But if it does change or compromise any of those things, then you do have to have a seal.
Roof is destroyed. Is it still an existing roof? Or?
Well, repair of a roof is different than a catastrophic collapse or something.
I think this falls, it's kind of a gray area, because if it was roof damage, you call your insurance company, whether it's a residential building, commercial, unless you have actual physical damages to the structure itself supporting the roof, that's carrying the roof, it could be a roofing contractor that could come out and give the same recommendations.
Yeah.
Yeah.
So really the only thing we're talking about here is a guy from wherever representing himself as an architect.
And that's and
I'd like to make
one of the
Can I
things
make a motion?
one of the things Steve just showed me is as part of this report, the guy included his resume.
I think he was getting involved in a legal deal, and that's why he did that. But that's just me. I'd like to make a motion that we assess a civil penalty of $100 for the use of the word architect in the state of Tennessee, because
Send a letter with that.
yeah, send a letter caution more. Which
In the cover letter when they get it.
What about law and rule exempt?
Yeah.
He's not even licensed in it.
Had he said that he's not licensed in Tennessee, then he's to me he's clarifying that so that anybody that would look at it, building official in Tennessee would understand that. But it's a gray area.
Is that a motion? Who's seconded? You need. Okay, open for discussion. Any more discussion?
I have a statement.
None? Okay. So
You realize that you're approving this for a formal hearing, so if he refuses to pay this, we're going to have a formal hearing. Because this is a
Okay,
settlement
right.
offer. If he doesn't pay it.
What's the point? Is you think that it should be asked more just a letter of warning or a letter of whatever versus
I mean,
to avoid having the cost of having a formal hearing?
there's no complaint history for him. $100 is I guess that would be pretty nominal. But if he doesn't send it, it's going to cost. And not that that matters. But we would have it would be we'd have to have a hearing, which is going to at least $1,500 for us.
But it will also cost him more
It would be charged back to him.
to come to a formal hearing, just to show up, his time and effort.
And I don't think, to me, the money part wouldn't be the issue. It's the claim and the finding.
I think there's at least an average chance he won't pay that, just out of pride, you know. Obviously, he considers himself a professional, or he wouldn't have used the terms and the letterhead and all that. I just think if you're going to assess a penalty, it ought to be
What if they revise the recommendation or the motion to issue a letter of warning?
I'm not telling you what to do. I would recommend probably a warning letter because he hasn't offended
I
before.
amend my motion to recommend a letter of warning.
And as the one who reviewed this, I would be okay with that because I think what we're talking about more than anything is a Title Act violation. This report didn't put the public in danger, but just
Not
the
from
mere
around here.
Pardon me?
Apparently, he's not from around.
No, he's
here.
not from this state, but he obviously knew this was architecture. He had it all in his report. That's what his firm does. His firm just isn't in this state. An attorney who was working on the insurance claim contacted him. I mean, this is what he does, but he's not licensed to do it in Tennessee.
So we have an amendment, a letter of warning. Okay, Wilson, you will second it too? Amendment, okay. Any other discussion? All in favor, say aye.
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 All right, motion carry.
Okay, the next one is one that Mr. King had, and this guy's a registered PE, and he stamped all phases of a project, which is a possible violation of service of areas of competence. And Mr. King again reviewed that set of plans to see if there's any merit for possible discipline.
Or for a church, and they're very minimal. And he stamped. He is a registered engineer in Tennessee, and he stamped all the sheets, including what I would term architectural. Would be amazed that he has that expertise.
Do they appear complete?
No, they appear very incomplete.
What's the size of the does it say what the size of the congregation is?
There's 192 seats in the new sanctuary.
That wouldn't have to go to the fire marshal's office for approval, because if it's under 300 for a church, you get a letter, the fire marshal's office will issue a letter saying that they do not have to review it. But still, local authority, it's very questionable.
It is still an assembly occupancy.
Right.
And Steve, we just went over this with an architect stamping.
Right, it's the same thing.
It's the same thing. It's practicing outside your area of competency.
That architect's plans were better.
Oh, even worse.
It definitely meets the criteria for needing to be stamped by a professional. It's big enough regardless of whether code authorities are looking at it or not.
I don't know if...
Rob, is your conclusion that it's a violation of 120-02-03, service in areas of competence?
I feel it is, and this guy's offended before.
What?
He's offended before. He's been disciplined before.
What kind of discipline?
Have that? It was a civil penalty.
Same offense, or do you know?
It was a similar offense.
How long ago was it?
That's 24 months or so. It hadn't been years.
You should have known better.
Have y'all had a formal or discussion with him?
No,
You
I don't
have?
think so. Not with this one.
I have not been involved in one.
We have informal conferences whenever the reviewer has a lot of questions and there's gaps in it. And why did you do this?
Do with number one. What was our?
It was a pretty heavy one. That was the $1,000 per incident.
$1,000, 6-month suspension. This person's original civil penalty wasn't that severe.
And if you go back to our guidelines, $500 to $1,000 penalty range.
Thought about having a telephone call with him to try to find out or really to confirm that he's not capable in all the disciplines.
Documents are worse than the one we reviewed before. I think it's a waste of time.
We've had one really, really similar to this in the last year. Same type of assembly. I just glanced over Steve's shoulder. Really the same level of detail in the plans, and
Elton, if you want to take a look at them, you're sitting right there. You're an associate member. If you want a second opinion on what condition they're in.
We're saying basically.
You want to see these too?
The plans are the proof that.
I think there's a letter in the file now that wasn't there when I got this information because it's dated February the 27th. But I want to read this. Is that okay for me to read a piece?
Don't name any names.
No. This is a letter to John from this individual. He says, on a low-budget project such as this, I usually put a layout of the lighting, electrical, and HVAC in the packet. This is to indicate to the electrical and mechanical engineers what the owner can afford. Now, he stamped this. We do not expect them to violate any codes, but we do need to hold the project to a minimum.
it does. On which component?
But we can't know the name of
Are
it.
you just saying is it electrical or
I'm
mechanical?
sorry, not what is his stamp. I'm sorry. What? Not the name of the person. What
page
of the
kind of drawing is
sheet? What is it called? Is it called preliminary?
No,
Is it
there's
called
no.
draft?
No, it's called no. There's no draft.
Electrical,
preliminaries.
HVAC.
Yeah, lighting, HVAC, sewer and water,
To it. I mean,
foundation, floor plan.
no notation with the seal that this is.
No.
Yes, but that seal thing is what's the word? It's a may instead of a shall, I believe. You are supposed to put it's for construction and all that kind of stuff. I don't think you're man.
There are.
Did he put some sort of? Is it just a stick design of the electrical and stuff, or is it just with no real detail?
Sparse,
Yeah.
Very sparse.
I had a similar deal on this one time that I was looking at for somebody, and they just kind of put a box in the plan that said so-and-so goes here and didn't put any details to it or whatever. But again, we have to stamp something to submit it to a building official. I mean, we have to. That's part. But we're not, based on the way our rules may have been at that time, we're not 100% obligated to put for construction or for review only or any of those kind of things. I mean, it's tremendous practice, but it's not mandatory if I'm not mistaken. So
we
It's
have,
not, but I'm
it's
sorry,
good
go ahead.
practice.
We have in our sets of documents sometimes fixturing by owner and things like that we include, and there's clearly marked reference drawings only. There's no stamp on them, and that's totally within our bounds to do that because we didn't prepare them. The reference shows you where the like a department store or something like that, where the aisles and all that information that the owner will be installing, and we don't. It's a reference drawing.
But you do that, Scott. You've got really good practices. But again, this board's jurisdiction is not that everybody has to have those really good practices, because you don't want to get sued.
But there ought to be some minimum standard, and any of us ought to be able to look at a set of drawings like this and say, yeah, hey, these are relatively complete. You could actually build by them, or they're substantially incomplete, and these appear to be substantially incomplete. And I understand the circumstances. Just as a point of clarification, it's a very local engineer doing a project for a local church. Probably is at some level a favor.
No good deed goes unpunished.
Yeah. But again, that's what we're charged with the responsibility of doing. And
before anybody makes a recommendation or a motion, whatever we do on this case, if it is not equal, I made on the previous case. I just want that on the record.
But I think this is maybe, and I don't know for sure, may be different, because I think in the other case there was actually a design done. In this, I'm not sure there was any design criteria put on there to do that. That's
Well,
just
you
my-
stamp a set of drawings and you submit them. I think that indicates design.
You have to stamp it to submit it.
yeah, Rick, yours may have been a little more egregious than this one. I didn't see. I don't want to. I'm not inviting myself to look at it.
It sounds to me like that's a set of plans that somebody designed, put their seal on, and wants the contractor to design it.
It's
I mean,
what
that's
we're
against
doing here.
everything we're doing.
Exactly.
You know?
Now,
They're-
again,
they're
I don't.
trying- They're trying to get plans through code review to get a building permit, and they're allowing the contractor to design the system, which is not according to all our rules. That's not what we're doing.
In the case that we'd had earlier, we actually did a telephone interview with him and had a list of questions, and we satisfied ourselves that he shouldn't have been doing what he did. And he acknowledged that. I won't be doing that again. My suspicion is this would be much the same case. If we were to conduct some sort of a teleconference with him, my guess is that he probably thought nobody would see or review this, and it's just something relatively simple. He's doing a favor for somebody, and we'll just turn it in. Well, unfortunately for him, I guess, somebody saw it and turned it in, and my opinion, based on the level of detail in the plans, is he shouldn't have done it.
And he had already been, if I remember correctly, in the past 24 months, he's already been disciplined for doing the same thing. So he knew.
Well, again, we've got the guidance says $500 to $1,000. Obviously, there's mitigating factors that you can consider. Not up to.
A recommendation. Are we still talking?
I mean, based on I guess the facts that we've got, I would recommend a civil penalty of $1,000, which is the max that we could do for this one project, and a letter of warning to not practice outside your area of competency.
So,
and take and pass
yeah.
the law and rules exam.
Bill, is that taken into consideration that this isn't his first time that this complaint is?
I still need to have, I think based on what we've got before us, I really can't take that. I mean, I'm doing the max kind of per our numbers, per our guiding in the numbers. So we're staying consistent with our policy.
Reading the rules on the
Aggravating factors.
I mean, it's there's even a rule in there that says each day of violation may constitute a separate violation. If he spent 2 weeks working on this, I mean, you could build it up to a bigger number with the rules that we have if you want to.
I'm going to hold with that recommendation and see how the board.
Withdraw?
No, I'm going to.
He needs a
Okay,
second.
hold on. I need a second on that before discussion.
Right.
The motion is to recommend a $1,000 fine with a letter of warning and pass a law and rule exam. How could I forget my own rules? Do I have a second on that?
A second motion.
Okay, second the motion. Open for discussion. No, hearing.
The per occurrence, we find the previous one we just suspended his license on. we find him per drawing. That was a per occurrence.
For discipline.
For the discipline.
Yeah.
But it was for the financial. We used the number of sheets to wind up getting to $4,000, not on an occurrence. That was the number outside of his area of expertise. So I want to bring that to your attention because
How many sheets of the?
he's an engineer.
I know, but he didn't provide.
Oh, well, okay.
Civil.
One less $1,000 he gets fined or whatever it is.
How much for grading plan?
In sheets, and they're all very sketchy. Minimal detail on all of them.
We did $500 per sheet on the, and we had it wind up being $4,000 fine previously. So I'm just bringing that to your attention because I think the
9 sheets. I'm sorry.
9 sheets. So the penalty needs to be equal, or I intend to make a motion that I withdraw my motion previously on suspending the architect's license and reestablish a civil penalty. So just that you know.
I was thinking on the other one, we did it on not sheets, but on disciplines.
There are 3
Am
disciplines.
Am I remembering that wrong?
Yeah, that's right. It was by discipline, not by sheets.
Rather than sheets.
Yeah, it's by discipline.
So you got 3 disciplines, really: architecture.
We had 2 sets of plans and took 1,000 times 3 for each project.
Right.
That's how we got. I think that's how we got.
That's how we got it.
But I don't think that's how we did it on the first fine, the first $4,000 penalty.
$6,000 fine. Yeah,
$4,000.
$4,000 penalty was based.
Or less.
Yeah, and that was based on my memory serves me correctly, number of sheets.
You can
Rick,
cut
I think
it
that was in regards to his first penalty.
Yeah.
And then his second one was 6,000, correct?
Correct. And this
Okay.
is this person's second
Right.
penalty, and I'm
Right.
not hearing a revocation here or a suspension. So that's my point. Is that
I agree with your
what's
point.
good with
So-
for the goose is good for the gander, and I may not get a second, but I intend to make that motion. So.
Did your person not admit that he had done this numerous times previously?
We don't have that, other than he said that he provided services similar to this on other projects. That was just a mitigating factor for us.
Or
But we don't have an aggravating factor. We don't have any complaints on that. But that was something that he provided.
Based on your discussion, I could go $500 per sheet, amend my motion to $500 per sheet times 9 sheets, which is a total of $4,500. I'm still recommending a letter of warning because, one, we have not had a discussion with this individual. Although I think based on what they're showing, the plans are showing that kind of criteria, that's why I'm going with that recommendation. So I'm amending my motion to that effect.
Who seconded the motion now? Was it Wilson?
Wilson?
Susan.
I have no idea. But if I did, I'll second that one. And I'll second Rick's when he makes.
All right, so we have amended motion to fine this individual $500 per sheet, so it's not them with the $4,500 with a letter of warning, taking part in law rule exempt, right? And then second by Wilson. Any other discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? Motion carried.
Right, the last outstanding case is the one that Mr. Wagster did, and it was about a PE that possibly committed misconduct by stamping all phases of a project that he wasn't qualified to stamp. So, Mr. Wagster, those plans?
Yes, I did. This is another church. It's an assembly building. And I guess, to me, the interesting thing about this set of plans is at first glance it looks like it's got a lot of information and is done like it should be. However, when you start looking closely at it, the other thing about it, this was referred by a building department due to the fact that it had been sealed, all parts of it had been sealed. And the set of plans that I received were actually post their plan review. So they've apparently they're in better shape than they originally were. And I guess the best thing I could do would be to cite some examples. For instance, his plans show that the building is, and again, it's assembly building, so it's supposed to be reviewed. But whatever the square footage, but it shows to be 3,200 square feet when actually it's 5,760 square feet. It's supposed to be reviewed either way. And he based his egress design and so forth on the sanctuary holding 180 people, where by code it holds 242. Drawings don't show any required rated walls. The door schedule shows 90-minute doors several places that don't, they're rated walls. Some of them are exterior walls. I almost wondered if it wasn't another set of plans that had been revised or something. There's building and truss sections that are pretty much single line. And I understand wood trusses are normally designed by the wood truss manufacturer. But anyway, there's very little connection details, and the sanctuary part has a scissor truss design, which has some horizontal forces on the exterior walls. It really doesn't show how any of that's taken care of. But I guess the truss guy would not have any horizontal forces. I don't know. But there's nothing to tell them that, I guess, where I'm going with that. The pretty much the lack of detail, and again, I've said this earlier on about that, but it would depend on the contractor to do a lot of the design of the building. The mechanical drawings, according to my mechanical engineer, are incompetent. They're under design. In other words, we've got a 6,000 square foot building. We've got 242 people in the sanctuary. He has a calculated outside air of 1,350 CFM. The whole building has 8 tons of air conditioning in it. Mechanical engineer Yeah, exactly. I mean, the other part of that is he shows on the drawings these are split systems. One the fan coil's in the attic, one of them's inside, but then he's got a mechanical schedule, and what he's scheduled are pad-mounted exterior package units. But anyway, even the outside air calculations, I got my mechanical guy to look at it, and he goes, those figures are based on something out of the 70s as far as ASHRAE goes. So. Even the accessibility, he's written on there that the restrooms are accessible per the ADAG, and there's nowhere near enough clearance in the restrooms to meet anybody's accessibility requirements, not to mention the 2010. The site plan, I mean, he's done all, he says, in fact, he signed a letter saying he was competent in everything that he did, and he says in landscape architecture and civil and structural and electrical and mechanical, and so he signed the letter saying he's competent in all this. And I guess that's the scary thing, is that he might think he is. I don't know. A site plan, in other words, he's got a site plan. It's better than this one over here. It shows a building on a site that a surveyor apparently did, but there's no dimensions to locate the building. There's no finished grading. There's no indication of plumbing, utilities, where a fire hydrant might be, no sewer location. It's just a survey with a building popped on it and some parking. The electrical plan says says 2 light fixtures or parking lot lights, but it doesn't indicate where they are on the site plan or the electrical plan. And the electrical plans, it's what I call a residential architectural version of an electrical plan. In other words, you draw the lights and you show what's switched, which I'm sure y'all are familiar, probably seen those before. And I guess the thing that concerned me about that is he had a 200 amp panel to handle all this. Got a riser diagram showing the meter in the panel, and he shows calculated, if I remember right, this from memory, calculated load on what he's got is like 185 amps, and that's diversified already. But he forgot to include one of the air conditioning units in it. One of the air conditioning units is showing in an attic. There's really no place to put one in the attic. He's showing ductwork going through a scissor truss. Maybe you can do that. I don't know, but it'd be hard to do. And then his distribution on the mechanical is not up to par. Let me put it that way. The plumbing sewer drains to a quote wet well, which is not shown on the site. I don't even know what that means. But,
that's another term for manhole.
Is that like daylight?
Could be another term for manhole.
That means he's going to get pumped somewhere.
Yeah, I guess. Yeah, somebody else pump it. And he's got some scheduled plumbing fixture. In other words, he's got the schedules and all this, but if you read any of it, it's not too good. But like he's got fixture drain sizes that aren't right, 1.5 inches under 4. They're just not right. I mean, he's got sink drains that are 3 inch. So I don't know how to respond to that other than
They may be doing a lot of washing.
And the other, yeah, big sink.
Taking a bath in there or something.
Also, the code officials had asked for a fire safety plan. He didn't, and UL ratings on any rated walls. Since he didn't show any rated walls, I guess he didn't need any UL ratings, but he had no fire safety plan or anything like that. And again, I don't have an in-house electrical engineer, but it was pretty much like I was saying, what I know about it. It doesn't look done correctly. It's small enough it wouldn't be required to be. Anyway, I don't know if I've compared to this other guy. This is a fine set of drawings. And I say that because I actually have seen those drawings that you looked at, but I'm kind of new on this. And I don't know the difference between a warning and a reprimand. But there needs to be some, something done. I don't know if it's this is strong enough to say, and he's got, let's say 10 sheets. I don't know exactly how many it is. I think it's strong enough to find $5,000 worth. But I guess to me, and again, the architectural is just doesn't have the detail necessary, and to meet the standard of care, in my opinion. Engineering part of it, again, I had a mechanical engineer look at it. He says, this guy doesn't know what he's doing, basically. A lot of things that are left out. And so, I would say a minor fine and a letter of warning, maybe.
You mean to read out the difference between the warning and the reprimand?
Yeah.
Letter of warning, evidence of violation, registrant may acknowledge violation and or have some plausible explanation, insufficient evidence to warrant suspension or revocation. And letter of reprimand is strong evidence of violation, but for other compelling reasons, not a suspendable or revocable offense. Registrant is lucky he or she is not at an informal. Next time, it will be formal.
Here's what I would like to do, I think.
Sounds a lot like Rob's editorials.
Go ahead, Frank.
I kind of think it's due a reprimand, but I would like our electrical and mechanical engineer on the board to look at it and give their opinion before I said that. Otherwise, I would say a warning, because the reprimand.
Is this the first any history of offense for this one? This registrant, is it the first time? Yeah.
I don't recognize the name, so I don't think we've done anything to this person.
Well, I mean, the fact that he don't have any history, and that he also signed a letter or affidavit that he is competent to do that. There's no reason to question him other than you might suspect that you might look at his drawing and say it's poor quality. I think for a minimum, at least a letter of warning this way. Find him the first time, I don't know, and then at least let him know that we're keeping an eye on him, and then when he comes back again, that's where we can really start to scrutinize him a little bit. That's my thinking.
My comment is I see somebody put 8 tons of air conditioning in this building. There's enough misinformation there that he's saying he's competent in designing.
Probably the contractor takes over and probably did it for him.
This isn't an architect who signed all the trades, is that? An engineer, did he sign, one person signed all the trades?
Architecture,
including architecture.
Man.
There's indication he's a registered land surveyor also.
I think, Frank, you point out enough of the discrepancies, and this is a situation to me where it's even a little different than the last one. This person's representing they know what they're doing rather than leaving some things out there that could be potentially added later or done later, because he's got enough detail to go ahead and build something by. And again, to me, that's a differentiation between the last one and enough detail to even build that thing by. I would like to see us, for each trade, give him a penalty of $500. So what, there's 3 trades represented, and that may be wrong, you tell me: electrical, mechanical, electrical.
Electrical, mechanical, civil, structural, architectural.
5 trades.
And I don't know if I guess plumbing would be under the mechanical.
If there's 5 trades represented, maybe do it at $250 a trade. So whatever that ends up being, $1,250. And a letter of warning.
Is this the Rule 0120-2-.03, failure to perform services only in areas of one's competence when qualified by education or experience in the specific technical field? Is that what we're talking about?
Also, the licensee may not accept work for which he or she is not qualified.
Well, just from that rule, the penalty range is 500 to 1,000, with mitigating factors of 500. Normal per violation is 750, and aggravating factors, you can find them up to $1,000.
My motion is then that we would fine him 5 trades at $500 per trade, $2,500 in letter of warning.
Let me read this from his signed statement here. Says, I am competent in the design of architectural, landscape architectural, civil, electrical, mechanical, plumbing, and structural systems.
Plumbing, I mean, there's...
Plumbing, mechanical, we can lump it together. And then a landscape, maybe I trade to be fair. I trade. Okay, so we got a motion here. Motion is that we fine each trade $500 up to maximum 5 trade, which is $2,500 with a letter of warning. Take the law and rule and pass the exam. Do I have a second on that motion?
Second it.
Okay, we have a second. I'm open for discussion.
Question: Is there any component that was competently designed? I know the answer on this one. I saw
He
it.
had a foundation plan that was okay, but there were assumptions, that without any geotechnical, he assumed the soil was this, and he put 2-foot wide footings around the perimeter.
Remanufactured metal building. Can you?
It's
not.
It's block, continuous footings, trusses.
More discussion? All right. Now let's vote for it. Those in favor of the motion, say aye.
Aye.
Any opposed? Motion carried. Thank you. Do you need to visit anything, Rick?
No, I just, was that the last case?
Yes, that's the case.
What's the proper protocol for revising a motion?
I don't have my Robert's Rules book with me, but I think you'd make a motion to reconsider the previous vote.
I would
Yeah.
make a motion to reconsider the previous, fine,
You want me to read the case number to you?
please.
I think you're on page 10.
Right here.
Case. The case number that you're referring to, Rick, is RBS 21202681.
Thank you, Mr. Chairman. Based on discussion that I previously brought up, I would like to reconsider the motion of the suspension and also revise the civil penalty in light of other repeat offenders. I would like to make a motion to issue a letter of reprimand based on the civil penalty guide. We are with mitigating factors or aggravating factors, excuse me. The way I interpret that is that he sealed 9 documents outside of his area of competence, 5 on one project and 4 on the other. And I would like to recommend a fine of $1,000 per document for a fine of $9,000.
And what?
And a letter of reprimand.
Okay.
Laws and rules, yeah. In lieu of suspension, and if he takes exception with paying the penalty, then he can come visit.
I have
Second.
All right, got a second to that motion. Any discussion?
I think you vote on the motion to reconsider first.
Yeah. Oh, okay. Let me start over again. I'd like to make a motion to reconsider legal case number
201202668.
Second it.
All right. Thank you.
Okay.
And my so.
No, we need to vote for that.
Oh, we need to vote for that. I'm sorry.
You got to vote to bring it back to the table.
Okay, any discussion on that? Hearing none, just vote in favor of it, say aye.
Aye.
Okay. So you can reconsider.
Okay, thank you.
All right.
Thank you. The reconsider, the new motion would be to issue a letter of reprimand, which is the strongest letter we can issue, and to fine, apply a civil fine for 9 drawings that were sealed outside the area of expertise and competence for a penalty of $1,000 per drawing for a total of $9,000. And if that, of course, and also take and pass the law and rules exam. That's my motion.
Okay, that was a motion. Who seconded your motion earlier?
Second.
Okay, well, second. All right. Any other discussion? Hearing none, let's in favor of this motion, say aye.
Aye.
Any opposed?
No.
1 opposed. So motion carries. Mr. Attorney, you're looking at me.
I was just wondering, just as a point of clarity, a fine is a criminal penalty, and a civil penalty is a civil penalty. So we should properly refer to them as civil penalties rather than fines. Fine is what a criminal court does. Doesn't matter. Difference without a distinction. I was a little bit curious about Mr. Campbell's objection. Might be something, we can learn from. Don't want to.
I go back to the same objection that I had before in the same motion, so for me to restate it. The gentleman that we talked about earlier did a stick drawing on something that was never meant to be built, couldn't be built. This guy right here was a repeat offender and made plans and specifications on something that specifically could be built incorrectly, and put the public at harm. When you've got 3 lines on a piece of paper that show a transformer coming out of somewhere with no sizes or anything like that, it can't be built. It's just a crappy set of plans. But when you put together a document that can be built and can be constructed and is incorrect in its construction, that's when we put the public at jeopardy. So that's the reason I objected to it. And I'll shut up, but I have danced on that dance before.
Whenever judges write opinions, there's a dissenting opinion sometimes, and sometimes when you read them, the next time something comes along, that actually becomes the law. So sometimes it's useful to hear that.
I think that's close to finish the legal case. Ladies and gentlemen, we've got 29 minutes to get to 4 o'clock because the engineering committee has a meeting coming up. Then we have 2 interviews. So we have a list of things that needs to go, so I'm just going to write on and with it. Next on the agenda is engineer committee report. Real simple. That the engineer committee met this morning from 8 to about 12:30 with all the deans of College of Engineering. We have all the deans represented except University of Memphis. They that was not represented here. There was some good discussion about area of the CBT exam, and I almost call him Alfred. Mr. Elton actually led most of the discussion. Anything else you want to add to it? Besides, we talk about CBT, and then you talk about FE and all this.
Well, it was a long, lengthy agenda that took the whole time, and we even short-circuited some things. I think the result of that is the deans all agreed that it was a meaningful meeting. They enjoyed it because of the interaction and what they could learn from one another, and we've agreed that there may have been other agenda items that we hadn't thought of, that we hadn't thought about that were important to them, and we gave them the opportunity to email their future agenda items to John, and we'll approach and consider those in future meetings.
Thank you. I think you did an excellent job on it. Thanks for the lunch, too. And also, Ricky, actually, and together, I believe in consultation with, I keep forgetting people's name today, How Bartrup. They presented I want kind of Ricky and how the Germany help me on this. The Continuing Education Committee has developed a form. Basically, what are the minimum requirement information that we want registrants to submit when they submit the PDH. And you should have I believe this is in the...
It's on the iPad, too.
On the iPad, right?
Yeah. Let's see.
Page 50 and 58.
Page 50 to 58. And basically, what we were talking among ourselves, the engineering committee, is to help facilitate the type of, to help register and to help us as we evaluate. When you claim for PDH, these are the minimum information you need to be submitting. Like, your name and what seminar you go to and who is the sponsor, so on and so forth. And then on the second page attached to it is a summary log that you actually turn it in when you turn it in for audit. And there's some detailed information with that. Ricky, you want to kind of jump in? Anything?
Yes, this would give us the information we need when we audit the continuing education, as we continue to get logs that just show the titles of the sessions or seminars, and you can't really tell whether it's relevant or not.
Mm-hmm.
And this would give us that information, and what this form that Hal put together that we've reviewed and commented on would go in a reference manual and be on the website, or I don't know if it'd be in the reference manual, but it would be on the website. And
that's right.
That it would be the recommendation that you either use this form or the certificate that you have, at least have this information on it.
Right now, if anyone turn in, one of the evidence is certificate, but sometimes there's some missing information. So this form that Ricky is referring to is at least help them track those PDH hours they go to. Is that a good way to
It'd
put
be
it?
something if we have an audit, like we have some problems with the way TVA presents the computerized
report, yeah.
report, we could at least point them to this on the website to say this is the information.
Question is, John, do we need to adopt it as a board, this form?
Well, the PDH summary log, you would, I think, need to adopt changes to that form, because that form's specifically referenced in the rules. The optional form, not necessarily.
It's the second piece that we need.
The summary log, if you want to adopt that format, I think you would need to vote on that.
Oh, we adopted. Any other question, any discussion? Thanks, Ricky.
Is this specific to engineering only, or is this across the board?
All disciplines.
All disciplines.
Yeah.
For this board.
Okay, yeah.
What if you see, actually, to me, the summary log actually a little bit better. Expand in-house online conferences. In the past, you just talk the type of activity, but this is a little bit expand a little bit better for you.
This be in addition to, like for an example, when we submit our AIA and other continuing education credits that's documented for HSW and those kinds of things? This would be an additional form we would have to fill out.
I think the same procedure would apply that we use now, that if they have an AIA transcript, normally they just put see attached transcript. Isn't that normally what
I
you see
just
on
went
the-
through this in Kentucky. I can tell you I had to do both. Yeah, I mean, we submitted that, and then they kicked
Right.
it back and said, you need to fill out this form, even though I had my AIA accreditation form attached with all the approvals and stuff.
I mean, all the same information.
It was exactly the same information. So
the way we
I
do it
wondered
in
if it
their
would be in lieu of or in addition to. I'm just asking the question. I'm not against it. I'm just.
Yeah, usually,
If you-
we accept the AIA
And I think that would be a
transcript and-
staff
Right.
decision.
We don't
Like, this is
require
fine,
them
you
to
don't have
fill
to
it
do
out on
this.
the log too.
But if you're not in an AIA member and you keep track of your own records, this would have to be.
Right.
Right. Okay. Thanks.
Okay, any other discussion? If not, can I hear somebody to make a motion to adopt this summary log sheet for the PDH?
So moved.
Okay, do I hear a second? Second. Any other discussion? All in favor, say aye.
Aye.
Likewise. Okay, motion carried. John will adopt the new summary log sheet.
Who developed that?
Al and Ricky Lane. Ricky.
How did it, Ricky?
How
check
did
the-
it?
Check spelling.
How did- That looks good.
Okay, we want to go on with the John, some unfinished business, John.
All right. We have action items on page 23 on your iPads. I did send a letter to the freight carrier expressing our concern about the condition of the culvert. That was a case that was presented at the last meeting. I received a letter from the freight carrier. I guess we still need to keep their identity anonymous, Rob.
Oh, the matter's closed now.
Oh, so I can tell them who it is.
They can't bring the same complaint again.
Okay. Well, it's a major freight carrier in Memphis. I'm sure you have no idea who that is, do you? This would be from FedEx. Their response was the Hurricane Creek. Well, actually, they're just stating what we already know in the first part. Basically, they say that they've inquired about the current condition of the culvert with the Memphis Shelby County Airport Authority. We were told that they inspect the culvert on a regular basis, and there has been no material change in the condition of the culvert from 2010 when the prior assessment was done. They're monitoring the condition of the culvert lying beneath its leasehold. That is, FedEx is. In the fall of 2012, it was inspected and found to be structurally sound. They repair and seal the surfaces of the culvert as needed. We will continue to inspect the culvert on a regular basis, and if necessary, remedy any issues we discover. We will continue to exercise due diligence, as referenced in your letter. So that's the response we received from.
That was a good response.
Yeah, that's all we could have expected, I think. We did also prepare a rulemaking hearing notice, which is on your agenda. Still waiting on that article from Mr. Thompson.
Working on that.
No pressure, no pressure.
I want to thank all of you for assigning me that when I was late for that meeting.
Yeah, great. And I guess the Finance Committee's working on their charge. Nominating Committee, that's been taken care of. They had their meeting today. I don't know about the Construction Administration issue, if there's been any progress on that. I think Mr. Waxter had volunteered to head that up.
What was I thinking? Actually, I have spent some time researching this, and the one I'm trying to get together with is Connie, because she's got a pretty good history with trying to deal with this. I have talked with several people throughout the country that, and email back and forth with, that have proposed this in their state to their states. The biggest problem is exposure. For example, most any building over 5,000 square feet is required to be designed by liability, and again, I've talked to liability insurance carriers also, but your liability extends till the building is constructed and sometime thereafter. Depends on what state you're in and so forth. But if you design a building and you submit the plans and they're approved, and then you have no more contact with it, and changes are made even without your knowledge, you still are at risk. That's where my concern is, I guess.
It's even more difficult to prove that.
There is. Now, to be honest, I've heard some opposition to wanting this to be done, to require it from architects, because some of them don't like to do construction administration. So, I think they're not wanting to do their job personally, but that's a personal opinion. But anyway, and also looking at the way the NCRB has made proposed model regulations, model law, that they suggest being used to enact or to take to a legislature and get passed. And basically what they're recommending is that to define construction administration as being the practice of architecture. And by so doing, if anybody else does it other than a registered professional, then you are practicing architecture without a license or engineering.
Yeah, I was going to say, would you
and then that
consider expanding that to engineering?
That, yeah, I'm sorry, but to registered professionals, I'd say it that way. And that puts the policing action, if you want to call it that, to the board. In other words, if and the ones that are against this obviously are developers. And I know Connie's frustration usually has been any type of legislation like this proposed usually is looked at as us trying to line our pockets. And so that's especially in North Carolina, I've talked with 4 or 5 people there that have been involved in trying to get that enacted in North Carolina. And well, they're pretty much saying that's the resistance they're getting. And a lot of cases, it really does affect the health, safety, and welfare. The biggest example that the insurers bring up is that Kansas City failure where the walkways fell in and killed a lot of people. And that was a lot of the problems that arise in a construction process, in a construction project, are due to interpretation of the drawings. And so, if you're not there to interpret them, that really affects how effective our drawings are, or our specifications. Go ahead.
Proof of what you're saying about health, safety, welfare is that insurance companies make us, when we buy liability insurance, we have to answer questions about how many of your projects have or do you not have construction administration duties. If you don't, your rates are going to be higher, and that's kind of mathematical proof that bad things happen when designers aren't involved in CA. And that bad things that happen are health, safety, welfare issues.
But I'm not ready at this point to make any kind of, recommendations or anything, I guess you could say. I would like, I'm trying to get enough information to actually talk to some legislators. And power to do. Or is that a personal thing? I'm asking our attorney, I think, but do I do that as a board member, or do that as an individual, or does it? I haven't done any of that, so.
It has to do as a personal person.
Board members have to be authorized by the board to speak for the board. They authorize you to speak on the board's behalf. You can. You
Right
just
now,
can't-
if you're going to still find information, I think you can do it on your personal level. Until such time you feel like you need some authority from us.
Okay. I wouldn't do anything on, actually try to get something done without the board's approval.
But in summary, you're saying most of this is because of the developers.
I'm sorry, I missed
In
it.
summary, you're saying most of this is because of all these bad developers and these developers that we have out here? Greedy
Wilson, you
developers,
paying
would you call them
attention
greedy
to
developers?
I saw Wilson's eyes light up when I said that. Actually,
Never did a project where we didn't have construction administration as part of it. I can't imagine.
And this, state projects require CA. It's mostly a contractor wants somebody to do you a quote minimum set of plans, and I don't want to ever hear from you again. I'll take care of it type thing. Which
State
I've seen one of
requires-
those drawings right here.
State requires CA or but they'll have somebody else, somebody else other than the design professional.
But the letter said,
Well,
it
that's-
said the engineers and developers is what killed it. Architect guys, Vance Travis.
Good to know when the devil goes to bed at night,
As
he's
with
got
the
friends.
winds in our sails, the engineers sunk the whole idea at the finish line.
Saying.
So don't be blaming it on the developers.
That's why I say it's good to know when the devil goes to bed, he's got friends at night.
Did it say why the engineers? That
Well, let me see, Alton.
Halton? Is that what he said?
Halton.
No, it doesn't say why. It doesn't give the reason why.
I would be curious about why engineers would be opposed to requiring construction administration services. But
Are you ready to move on from action items?
Yeah, I mean,
Okay, all right.
because we're less than 11 minutes away.
Very good. I mean, we can run a little bit late if we need to, because we've got,
Plus we've got interview
rulemaking's
at
pretty
4:30.
important. But, yeah, we do have an interview at 4:30, so ideally.
Want to do
we
something important for the
get
room
done by
here?
then. Not behind, I'm about to say behind tab 24, page 24, you have an update on the marina issue from the state fire marshal regarding
do the
their
nominating
inspections.
committee?
I'm sorry? Yeah, we already touched on that.
Okay.
And all those-
Yeah, they met earlier today. And behind that letter, you have an email I was copied on from the mother of the boy who was killed in that electrocution last year. So asking for an update from the fire marshal on the status of their efforts to ensure the safety of marinas. So I thought I would share that email with you so you're aware of it.
On a question I had on that, if it's okay, I appreciate the fire marshals going out and doing these inspections on existing facilities, because that's kind of what this letter seems like to me. I'm still really concerned, though, that there doesn't seem to be just a great uniformity in new designs and trying to catch these things before they have to go inspect the problems out of them. So, again, I appreciate the work they're doing. I understand that this is a tough deal, but I'm still not sure that I see a real good answer to, here's a new design, we run in, rather than trying to go do it all later. So that's my concern based on that letter that I saw.
Comments on that? All right. Draft rulemaking hearing notice begins on page 26 on the iPads. And I guess you want me to provide a summary of the changes that are proposed? Or?
I had a chance to look at these proposed rules.
they're all basically the same as what we've already reviewed. There was, I think, one that was added on here from our previous discussions. Let me see if I can find that. Okay, there's two changes that we added on from previous discussions. One of these is just formalizing an existing policy of the engineer committee. That's a proposed change to Rule 0120.01.10, Education and Experience Requirements Engineer. And you have a summary, my summary of the rule changes beginning on page 47. And that is the rule that deletes the master's degree provision that the proposed change does. Also, we added on there language stating that engineering degrees from programs accredited by the Canadian Engineering Accreditation Board, the CEAB, that were awarded in or after 1980 are considered substantially equivalent and do not require evaluation. There's a bilateral mutual recognition agreement between ABET and CEAB. We've actually been following that policy for some time, that we've recognized those degrees, but I thought, well, we really need to put that in the rule rather than it just being an unwritten policy of the board. Actually, the only place it appears is in our application instructions. So I think that would be good to add to that particular rule. And at the same time, I thought, well, hey, we probably need to amend the education and experience requirements rule for architects. That's the next rule, 0120.01.11, to state that degrees from programs accredited by the Canadian Architectural Certification Board, the CEAB, or from a program that they deem substantially equivalent, would be deemed equivalent to a degree from a NAB accredited program, because those are recognized by NCARB and by NAB. The Canadian degrees are. So that it makes sense if we do that for engineers. We probably should recognize the same thing for architects as well. And this will also eliminate the necessity for us to contract with a professor in Tennessee to evaluate those Canadian degrees. There's just really no need to do that if they're already recognized as substantially equivalent by a qualified body. So, those are the only changes I think that we've made from what you've seen previously.
I have just one quick question.
Yeah.
On the page 38. Then the education question. I'm just making sure I understand that this is in item 1, the last sentence after we've gone through the 12 HSW hours. It says continuing education hours may be required at any location, and then it says excess continuing education hours may not be credited to a future calendar year.
Right.
Has that always been in there?
Yeah, that's the elimination of the carryover provision, and that's been part of their proposal.
But didn't we talk about having a rollover period?
This is actually an optional rule change. That's why we didn't have like a drop dead date. This is when it officially becomes effective, because it's optional at this point. So yeah, that's why that's why we left that out.
Thank you.
I've got a couple. One I think is a fairly easy thing, but it's on about registered. Let's see, 62. I've got rules of professional conduct, 0120-02. Number 5. Register possessing knowledge, must cooperate with the board.
Right.
And I've heard Philip say this before, that he would not give a recommendation to somebody that worked for him. And the way that's kind of worded is, if somebody comes and says, hey, you need to give that information, required to give that information, and that may put you. Am I looking at that right? I mean, to me, that's the way I read that. So if somebody that works for you, you may not want to give them because you don't feel like, but if you're given a reference, I'll stop stuttering here in a minute. If you're given a reference to submit, the way this is worded, I'm mandated to send that information in, and it just makes me feel, I mean, if that's not the way it's intended, we might need to just kind of massage that a little bit. And I think the way it was, if somebody calls up and says, hey, what about this person, or, so anyway, that's one that
I think this is intended to address really, I guess, two situations. One where, and I think the original intent behind the NCARB model on this, which we are sort of loosely adopting here, comes from NCARB, is the scenario where you have an employer has a falling out with an employee and basically says, I'm not going to provide any verification of your experience. I'm not going to. This is through NCARB's IDP program. They basically say, I'm not going to verify the experience that you've submitted to NCARB through IDP because, I hate your guts or whatever. You have a falling out. So it's intended to protect the intern. And then secondly, this also puts the onus on the registrant to make sure that they're supplying accurate information, that they're not falsifying any of that information, that they're verifying. So that's really the two issues it's trying to address.
Says employment and or experience earned by an applicant under his supervision, if reasonable assurance that the facts to be verified are accurate. And again, I think sometimes that may put, as a board member, sometimes that puts you at a little bit of a little awkward, because you may not want to give somebody a recommendation because there's a semi-conflict of it. If I see a board member's name sign something,
there's nothing that prohibits you from providing a reference. You just have to recuse yourself from reviewing the application. But we have accepted references from board members before. They just don't review it. So there's nothing that prohibits that.
I think, Robert, when I first brought up, one of the case you do not want to be is like when you are a manager like yourself, you really don't know enough of your employees' work. It depends on the supervisor and the lead, but yet you are the PE for the department, and it's always it's kind of a bit tricky when somebody come up to you. You made me a manager for that long, you not give me a reference, but I always tell them I don't give you reference on your character, but more your technical ability. So I can't give you a very good, honest opinion unless this is last resort. Even last resort, I still hesitate then. So anytime when it's just uncomfortable feeling on my part, I usually tell them, be very honest with you.
I understand why it's there, but it does seem like it may put you in a little bit of a...
And this is not really a new requirement. It's already in the rules. We're just kind of tweaking the language somewhat. So as I recall, when this rule was first adopted, that language that's currently in the rules, I don't think we received any comments about it. But, I mean, you could still go ahead and approve the rulemaking hearing notice and then tweak the language when we actually have the hearing. So you're not married to this language by adopting it for the hearing notice.
I've got one more, too, if I can find it. And I'm sorry, but it's the new stuff that we passed. Let me try to find it. Back here with quality-based selection, John. That's where it's at.
Qualifications-based selection.
Yes, sir.
Okay. That's paragraph 6 of that same rule that you were referring to. 0120.
Take something in between.
02.02.
Well, let me just tell you in general, because I can't find exactly where I had it down. But there's something that says that price basically should be you can't negotiate on price, and I understand that part of it. But some municipalities
Robert, I think that may be the after this. It's in a letter that he's.
Well, it may, but I had some notes and I can't find them in here. But there's some cases where a municipality will actually narrow down to a short list of 3 or 4 qualified people, and will not then ask for the lowest price on that. And when you look at it from QBS's standpoint, they've gone through a QBS process. You know, I just think we need to be careful kind of how we structure that, and maybe have some more discussion just on that piece of it, because on one hand, why we're touting QBS is it lets you get quality, and then somebody can say, well, look, I'm getting I'm making sure that my pool of applicants is, you know, and goes in the foot with that same argument.
That's and it's in your packet later on in the agenda. I got that very question where they were basically, for a municipality, they were pre-qualifying them based on their qualifications, and then all of those that qualified then submitted their bids. So it's not exactly the process that's laid out in the statute. The way I understand the statute, you select the most qualified person or firm, and you negotiate with that one person or firm. If you can't reach agreement with them, then you move to the next most qualified. But that's a discussion we've been having for some time.
That's later on the agenda under new business, correct?
Right, it is.
John, I want to let you. I want to ask the board. I want to let you finish this item, and then we probably need to put some of the action items to the next meeting. Let's handle the most important one, because it's really past 4 o'clock. I'm trying to get ready for my interview at 4:30 and 5. Okay, thank you.
I do have one I need to bring up. On page 44, under the rule 012-04-.05, experience requirements is amended to increase the number of applicants. I think that should be references for registration as a registered interior designer from 3 to 5.
Right, that's in Rob's memo.
Yeah, I think that word is supposed to read references as opposed to applicants.
You're right.
Okay.
Make a note of that, Rob.
Before you suspend the meeting, there's one comment I'd like to make. Just when
let me finish.
I am. I just wanted a point of reference. I wanted to let you know.
I think that's all we have on the summary of the rules. Now, Rob has a Regulatory Flexibility Act memo that you have to approve. How do they need to proceed, Rob? Do they need to vote on to hold the rulemaking hearing, I guess?
Page 41 of your pad is where it starts. This is something we're required to do by statute. I'll go ahead and read the introduction. The Regulatory Flexibility Act requires that prior to initiating the rulemaking process, all agencies shall review all proposed rules and the effect that the proposed rule has on small businesses. The Act requires that each agency shall employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small business. The Act further provides that the agency shall consider without limitation certain methods of reducing the impact of the proposed rule on small businesses or remaining consistent with health, safety, and well-being, and those methods are as follows: the extent to which the rule or rules may overlap, duplicate, or conflict with other federal, state, and local governmental rules, the clarity, conciseness, and lack of ambiguity in the rule or rules, the establishment of flexible compliance and/or reporting requirements for small businesses, The establishment of friendly schedules or deadlines for compliance and/or reporting requirements for small businesses. The consolidation or simplification of compliance or reporting requirements for small businesses. The establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. And the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase cost. Okay, and then the next thing underneath is just a summary of the rules. So let's just zip on ahead over to what page?
Page 45.
Now, regulatory flexibility analysis, methods of reducing impact of rules on small businesses. So, I'm just going to read these questions, and what's underneath is a suggested answer, but you don't have to adopt it like that if you have something else you'd like to answer it with. And then the board needs to vote to approve these answers to these questions. Okay, number 1 is overlap, duplicate, or conflict with other federal, state, and local governmental rules. And of course my suggested answer is there is no overlap, because the board is the sole authority for establishing minimum requirements for obtaining and maintaining a license for the professions it regulates. If a board member has some idea how these rules may overlap, duplicate, or conflict with federal, state, or local governmental rules, let us know. If not, you can just accept this answer the way it is.
Do they accept the answer one at a time, or?
We can just do them all at once, and then you can vote at the end to accept them.
Right.
We can amend them as we go. Number 2 is clarity, conciseness, and lack of ambiguity in the rules, and the suggested answer is the rules are clear in purpose and intended application, probably in intended application, and are not subject to varying interpretations. Number 3 is flexible compliance and/or reporting requirements for small businesses, and the answer, regardless of size, all firms providing design services under regulation of the board in this state are subjected to the same minimum standards. Number 4 is friendly schedules or deadlines for compliance and/or reporting requirements, and there's no variation in reporting requirements for design firms in Tennessee of any size. Number 5, consolidation or simplification of compliance or reporting requirements, and then the answer that I was thinking was these amendments and new rules do not address the operation of design firms, only individual registrants. 6 is performance standards for small businesses, and it would be the board only requires that design firms register with the board and does not issue licenses to businesses of any kind or dictate business practices of design firms. Barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase cost. The amended new rules proposed do not contemplate an impediment to innovation or increase in cost for providing design services. Okay, that's 7 questions. If the board would like to comment on any of the suggested answers or change them, now's the time, and then we can adopt them all.
I would move that we adopt them as you had corrected the 2 or 3 places that you made corrections.
Yeah, and that's
adopt them.
just a
Second.
typo.
Okay, we've got a motion and second to adopt. Any discussion? All in favor, say aye.
Aye.
Okay, so motion carried.
Okay, last page, additional questions posed by the governor's office. We have to answer these just like the other ones. Number 1, does the rule make it better to do business in Tennessee? Which is, I don't know how he could possibly know that. But anyway, Yes, by eliminating restrictive residency requirements and protecting consumers through advancing licensure of design professionals to match national standards. Rule make it easier to create jobs in Tennessee.
Say simplify on the last word of the third line. Reciprocity licensing. Or
I've typed this whole thing in about 30 minutes. Simplify, yes. Answer is yes. The amendments to eliminate residency requirements and to accommodate computer-based exams will bring Tennessee into agreement with all other national jurisdictions, streamline the exam process in every state, and simplify reciprocity licensing in Tennessee. And then, as you can see, it was getting late in the day. Is it essential and effective? Yes. Who does it affect? The new rules will affect all registered licensees of the board. Is the rule a positive move? Yes. I didn't really know how to expand on that one.
But that's my favorite question.
Is it a positive move?
He's going to answer no.
Yeah.
Anyway.
Maybe. Outcome-based. In essence, does it have a measurable positive outcome? Yes, the elimination of the residency requirement to obtain a license in Tennessee will make it much easier for registrants in other jurisdictions to come to this state and provide design services. Alrighty, so here's the sort of templated answers. If the board would like to change them, then now's the time. Make them more descriptive.
I would move to accept the recommendations from our attorney with the modifications made.
Okay, I have a motion to accept.
Second.
Second in the motion. Any discussion? Hearing none, all in favor say aye.
Aye.
Aye, okay. We carry. Motion.
Okay, now we can start the process of getting a hearing date.
Do they need to actually vote on the rulemaking hearing notice?
Yes.
Okay, I don't think y'all did that, so.
You need to vote to approve the notice too, but we've done this. So.
Right.
What was it again?
You need to vote to approve the rulemaking hearing notice.
Okay. Do I hear a motion?
I move that we approve the rulemaking notice
With the corrections.
with corrections.
I second.
Okay.
There were no corrections to the actual notice, though. I think Susan made a correction to
It's more typo, isn't it?
his memo, but not to the,
Okay,
the
all right.
notice itself.
Rephrase.
I move that we approve the notice, rulemaking notice.
Second on that. We have motion and second. Any discussion? All in favor say aye.
Aye.
Okay, motion carries. Hey, John, before I'm in my corner of my eye, I know someone's waving at me. Go ahead. Go ahead. What you need?
Thank you. The notice that you're sending out to the local government agencies about the qualification-based selection is excellent. I appreciate the fact that you're doing that. I would, in addition to sending it out, I think you've proposed to send it out to the local government agencies. I would also send it out to the to engineers and architects, everybody that this board represents, so they're aware of the qualification-based selection statute. I bet many of them are not.
Hey, John, let me ask this question. Can we, in those, like the, those NCAF and CLAF and the NCWS report, can that be noted in the minutes here that you will send it out electronic to us, or do we need to bring it back up again in the next meeting?
We could probably send something out electronically for those. I mean, you've already seen the NCARB report. We have a written report on that, so the others we could just do an electronic report.
Any other item that we need to handle here before I suspend the meeting?
So do you want me to send this notice out regarding the bidding on professional services, or do you want to hold this maybe for the next meeting so y'all have more time to review it?
I would like
perhaps,
to hold it till the next meeting.
Yeah.
Really, there's no sense to rush through it. Any objection? So we're gonna do kind of put the agenda item on the bidding of local public works to the next meeting and discuss that. How's that? All right. With that, I'd like to hear a motion to adjourn the meeting.
I move so that we so
All right, go ahead.
adjourn.
Adjourn the meeting. Who has, I need to hear a second.
Second.
All in favor? Aye. Okay, engineer committee.